In this case, my lord, this appellant transport is available in 2022, my lord.
Yeah.
The appellant, while continuing as a impeached male supervisor, you are transported to a long distance place.
What is that? How long it place?
More than 400 kilometers on the in the ground of penalty punishment. I approve, my lord. My lord, state there of transport. Despite staying, I am not allowed to continue. I file a contempt. After contempt petition filed and notice issued, they allowed me to continue.
They have allowed you to continue.
That intervening period, ultimately I joined in my place of posting where I have transferred.
Yeah.
Deputed.
So it has become infractional.
No, that 6 months salary they have not paid.
That they have to pay.
Now, I approached my lord. My lord, I had to consider. After that, they issued a show-cause notice to me. Without paying salary, they issued a show-cause notice to me under Annex 54. I approached the authority. I approached my lord. My lord issued notice and directed to register why that was not as duty.
How long you remained absent?
6. I have continued in service because of stay out of the position court.
You continued in
my place. 6 months dispute. I continued. But ultimately, I joined in my place where I have deputed.
What the learned single judge said?
I approached on single judge challenging the notice.
That's all right. Therefore, we ask you what the single judge said.
On single judge, after 2 years, they are not no counterpart for last 2 years. Unless space 60 on a single director, you file a show-cause reply.
Yeah.
That I challenge because one, their direction issued by additional court and they are complied and they are given undertaking that we will pay the salary. Thereafter, they issued notice. Therefore, my minor director to issue instruction how on the face of earlier or how is issue notice. And that order is passed.
Yes, Sister, why? Because of stay order, he continued in the same place. He worked there. If he works, you have to pay. Is it your case he did not work?
To take instructions without change.
Issue. Learned AGO, Madam Question also notice for follow office.
All right.
Follow office. First. Matter lies in another complaint. Question after 4 years. In the meanwhile, trading service.
All right.
I come to submission and necessary to serve.
My lord, Annexure 1 is in challenge. That's
What is
the
the
possibility.
order?
My lord, application for recalling was filed before the industrial
Tribunal.
no labor court, my lord. It was a person who had been dismissed following a domestic inquiry, and that became a preliminary issue to be decided.
And
And
the
when-
issue is as to inquiry being lawfully
Whether lawfully and fair or not. And in that matter, entire document sets the domestic inquiry, those were produced, which I have also annexed to this present application. But that preliminary issue was decided against the management only on the ground that the records have, though produced, have not been proved. My lord, at that
You
stage,
can challenge in the event. Award goes against you.
that's true.
Huh.
Even if it is decided against me also, tribunal can take a different view also.
That view is also available.
But here, if it is preliminary issue, your lordship knows that the object behind it, my lord, all those documents were there before the.
That's all right. Why
And
you should spend
I
time-
filed an application for recall.
That makes no sense.
Tribunal could have reconsidered that.
Whether it has got recalling power.
My lord, that your lordship knows that Greenley Bank case 11, section 11 of the
ID
Act, where they say that they can devise their own procedure and even
all right. But recalling order is not.
the recalling order, my lord, that is also Greenley Bank's case, my lord.
Yes, sure.
Your lordship.
They know that
Karnataka High Court judgment.
I am not good in labor law. My brother is good because he has handled so many such matters. Which is that?
This is 33 to be preliminary inquiry is held to be not proper.
It is not under 33 to be.
32 B. 33 to B.
No.
No.
Preliminary inquiry is there is a procedure to see, even preliminary the court can devise this procedure.
Yes, exactly. That is section 11. Your lordship.
Section 11.
And this has been.
No, what we are saying is, you may have a good case, but why we should interfere at this stage? To wait, and the principle which is enacted in 1976 amendment to CPC, Order 43, Rule 1, capital A. It is held to be applicable to proceedings of the kind by the apex court.
My lord, that's true. My lord, the object is that it can be cut short at this stage also. Your lordship is like
Not that.
to
It
say
can be is one thing, but why it should be is the question.
somebody who has been dismissed by a domestic inquiry,
Correct.
and the question is that whether it is fair or not, that has to be done.
That has to be done. Now it is held
Examined.
against you.
And the records were, my lord, produced, and even
That
if
may be
your
wrong. We arguably that may be wrong.
lordship may see that page 255, I filed an application.
No, your
all
point
those
of-
documents were accepted by the
No, we agree
Level
with you.
We agree with you. But why at this stage? You wait, because in the event the award goes against you, then you can come here. Suppose if goes against the employee, where is the question of you are coming again here?
My lord,
No, sir.
leaving
That
it
is
to
the-
that stage also, my lord, that will again multiplying it. Your lordship can say,
No,
because labor court can also examine it.
it can examine, but we do not want to say anything at this stage. If any order is passed during the pendency of a proceeding, that order can be made a ground for attacking the outcome, final outcome of the
My
proceeding.
lord, here it is not required.
Yeah, why?
Because even if it is decided against the management at this stage,
Still labor court.
still it is open to the labor court.
Exactly.
That's what, that was against you now.
But here what has happened, that even if the materials were on record, that non-consideration of the admissible materials
Material.
on record, that's a ground for revision and judicial review.
Not.
Lord, and that will, rather
That's
shorten
the proceeding.
that will shorten the time and the cost of the
No.
proceeding.
No.
For that reason, your lordship may.
Take off. The management petitioner is knocking at the doors of Red Court for assailing in order of the labor court dated so and so, whereby the preliminary issue has been decided against it. First, next one. Learned counsel, kindly be seated. Learned counsel appearing for the petitioner vehemently argues that the impugned order is prima facie legal in as much as it ignores the legal evidence available on record, and therefore interference of this court is highly warranted. First one. Next one. Having heard the counsel, he also submits that the labor court has power to recall the order pursuant to decision of Karnataka High Court in which is that? Grindley.
Grindley is the apex court.
Welcome group Windsor Manor, so and so versus Subaya. There this. First one. He also adds that even when a preliminary issue of the kind is decided by the labor court, it can come to a different conclusion after the trial. First, next one, having heard the counsel for the petitioner and having perused the petition papers, we decline indulgence in the matter on the short ground that the order now made is during the pendency of the labor dispute before the labor court. First one. By that order, the main proceedings have not culminated into any award. First one. The only issue decided by the labor court, arguably tentatively, is as to the legality and propriety of the domestic inquiry. First one. It is the case of the petitioner himself that the labor court can arrive at a different conclusion after the trial of the main matter. First off, we will not express any opinion on that issue. Next one. Ordinarily, the management should await the final outcome of the proceedings under the Industrial Disputes Act 1947. First off, it is not that by the said order, the remedy of the management is foreclosed once for all, in as much as in the event the award goes against it, this order made on preliminary issue can be made a ground for challenging the said award itself. This is consistent with the parliamentary policy enacted in Order 43, Rule 1, capital A of the CPC 1908 as amended by 1976 Act. And first nothing. In the above circumstances, writ petition being disposed of without granting interference. All contentions being kept open by being urged before the Labour Court. But registry to send a copy of this order to the respondent or OP workman for his file. Okay. Next, no question. The first question will not be because we are not issued with consent. Yes, sir.
I can say,
The order under Annexure 9 at page 54, the sale notice is under challenge by the borrower. They ground that on the date of issuance of sale notice and the date of fixed 7 to 12
This present application mail or writ application, I have filed an interim application mail.
Interim application. Well, notice is issued in this matter.
No.
Who are you?
Cabin was filed, I saw the.
Who
are you?
Purchaser, man.
Purchaser. Whether you have made him a party.
No, that was not. Sale
No,
was.
who are you? Unless the
I have filed my interim application mail.
who are you?
I am the bona fide purchaser, man.
Correct, but unless we take cognizance of the case, how can you enter in the fray?
I have filed already, man.
Kind is basically. Yeah.
Annexure 9, the sale notice issued.
Now, what is the loan, brother? Housing loan?
One is housing loan, one is business loan.
Two loans. Together, housing loan is how much?
Housing loan, 18 lakhs.
It was taken on?
Taken on, my lord, 31/8/2021.
What is the EMI?
EMI are 16,000. 700.
How many EMIs you have paid?
EMI, the details account statement said that near about to 21 EMI has paid.
21 EMI have paid.
But the document bank could not provide, that's why that may be. What's submission advance may be supplied. Vigilance loan was.
Once again, how much money is remaining now under the housing loan outstanding?
In their notice under 13.2, they have mentioned that 17 lakhs 7,232.
Then you have not paid 21 EMI, going arithmetically. Simple arithmetics we have been taught in the primary school. It cannot be that.
Then your business loan. Business loan also, the OD is 23 lakhs. One 10 to
OD is 22.
23 lakhs.
This was taken on
1/10/2021. On 13/2 notice, is 9. The outstanding due they have mentioned 23 lakhs 33,000.
How much you have paid? This in respect of this you are not specifically paid.
On the date of sale notice, there is a interest, there is no overdue. It was not came down from the slippage because there is no interest there.
No interest.
That the overdue, the interest once 3 months, then it will be NPA will be declared. So, but account statement I have enclosed. Let's see my kind of a glance. Page 42. The total outstanding is
Even against this. Even against this, your remedy
74 is out there.
17 is there. Here challenge is that improper valuation.
So that is a
And
matter of calculation.
the account was not overdue on the date of sale notice.
correct.
So,
That can be a ground before the tribunal also.
that also.
You take that, you go there.
Only protection may be third party not created so that will also.
Now auction has happened.
The auction was that information not given.
Huh?
No,
After
that-
the 17 to the date fixed, February, there is no intimation from the bank. Auction happened, was successful, nothing was communicated.
No, date of auction was on 27th of February. February.
February.
Now it is June. They must have gone.
Within what period? That is 45, 90 days.
45 and 30 days.
30 and 45. That is, but on this, you file proceeding appeal under 17.
Only but for purpose that 2 counts before a lordship.
No, that makes no difference. When there is a statutory tribunal constituted under the special act, why we should interfere? That too, our auction has taken place on 27/2.
So that intimation provides we can
Notice was there. You are from the bank.
Yes, yes.
You are from the bank.
Yes,
I can
yes.
caveat yes.
Yes. And for the
No, but whether auction was held on
auction was held and it has been successful
Oh.
and high
Did you
speed.
send intimation to
Intimation that we can party to the auction
you
procedure.
have not sent any intimation to.
No notice.
Intimation later, so then I can give you documents regarding that. Can give some time so that I can produce the.
No, let him go before the tribunal.
Let him go.
All contentions will be kept.
Yes,
So
yes, yes,
You
yes.
don't create third party interest in respect of the property. The other party has to do it. No? But how can we make that order? You make application before the tribunal for that purpose.
If bank will provide that intimation, so
Yes,
that
yes,
we can
we will-
have an
if
opportunity
it
to
is-
impede, otherwise it will prolong procedure.
Challenge is by the borrower to the coercive recovery proceedings, eventually resulting into auction sale of security property on 27 February 2026. First. Next paragraph. Learned counsel for the petitioner vehemently argues that the entire proceedings are marred by so many illegalities, and therefore the writ court should come to the aid of his client. First off, per contra, the bankers opposite OP Bank having entered caveat through the counsel opposes the petition, contending that the petitioner has got an alternate and more efficacious remedy under Section 17 of the Surface Act 2002, and therefore, in the absence of any extraordinary circumstances, the writ court should not grant interference. First off, we agree with this because that has been the practice all through in this court, subject to all just exceptions, into which argued case of the petitioner does not fit. Next one. The above being said, the bank has to furnish full details of the auction, name of the auction buyer, and the like to the petitioner, so that he can avail the remedy under Section 17 of the Act. This the bank has to do within the period of 1 week.
1 week.
1 week. First, in the above circumstances, this petition is disposed of, reserving liberty to the petitioner to take pursuit under the pursuit of alternate remedy under Section 17 of the 2002 Act. 2002. First, we make it clear that for the computation of period of limitation prescribed under Section 17, the reckoning fine would be the date on which all the material particulars of the auction are furnished by the bank to the petitioner. First. Next. No, please.
My lord, your lordship has passed the order that my lord Justice Das will not hear this because of his involvement.
This is the matter again, sir.
Again, it is.
Tribunal matter, ma'am. Against the tribunal order. And my information that endorsement has given by the Honorable Justice. So your lordship hear this my application along with the Honorable Justice M.S. Sound. I request the lordship any day next week.
Registry to post the matter after facing our order dated 5/5/2026, before appropriate pitch.
Okay.
Next.
The petitioner and his father, my lord, borrowed a loan of rupees 12 lakh, my lords,
When?
in the year 2016.
What is that loan?
Housing loan, my lords,
Housing loan of 12 lakh.
12 lakh. Thereafter, soon after that, my lords, his father died, my lords. And before that, my lords, the bank persuaded us to buy 2 insurance, lordship, one for the home and for the personal loan. On the account of death, 6 lakhs of rupees shall be awarded to us on the death. After the death of the father, your lordship, 6 lakhs was to be awarded. I intimated the bank that to deduct that 6 lakhs of the insurance towards the loan account. They did not do so, my lords. Thereafter, I approached the consumer forum. though bank appeared malus, they were set ex parte, but they did not file any written statement, nor they appeared after that. And the insurance company was set ex parte despite the notice, Your Lordship. In that account, the
Order is made by the consumer forum.
Consumer Forum, Your Lordship, page 42, may read that, Your Lordship. We therefore direct the opposite parties to settle the death claim and deduct the share of dead person, that is Bijay Ketan Mishra, and it is in between opposite parties number 1 and 2 to settle the claim. The opposite partner 2 shall deduct the loan amount from the principal as if the insured amount is, that is 6 lakh, has been paid to the bank, and calculate the loan after deducting the share of complainant's father. The date of deduction of insured amount is fixed as 19/6/2018, as it is clear that the death of complainant father was within the knowledge of opposite parties, at least not later than 19/6/2018. As such, the opposite partner 2 shall not claim.
Understood. What happened now?
Now, Your Lordship, they did not deduct the 6 lakhs. The insurance company did not give that 6 lakh to the bank. Now they have sent me notice under Rule 6, Sub-Rule 8, with regard to auction.
Entire money.
Yes, Your Lordship, the auction of that building, my only dwelling house. And there is
Your amount, whichever is payable by you,
malus.
you deposit here before the bank.
Your share, your part.
My father and we did it. As on 30th of April, it was 20 lakh. If 6 lakhs will be deducted.
Leave it. Your part is what?
Malus.
Your part remains intact.
My part remains intact.
You
But
pay
the
that, but it will end here.
interest calculation, malus, that will come to a lesser amount.
Slightly it will come down.
Malus, I pray if 3 weeks time may kindly be granted, I will pay the my share of what I can pay, malus.
You did not pay your share.
Malus, I was paying malus, but not but because my father died, I was self-employed.
Right in 2018.
18 malus. Thereafter I paid, but in
How much you have paid afterward?
in total I have paid 10 lakhs, Your Lordship.
After death of
No, after total in total.
that makes no sense. After the death of father.
Malus. That I have to calculate malus. I have given in partially 10,000 EMI installments. And periodically I have paid malus. The exact amount that I have to take instruction.
So you can execute the order of the consumer forum.
Consumer forum, that I did not do. That was the only predicament I did not do malus. But thereafter also they, as the same has been into
So not gone to the for execution. It should go for the execution.
Execution provides for arrest and detention.
malus.
That will be more efficacious remedy. Na?
With regard to this notice under Annexure 1, may I pray that no course of action till I file an application within 4 weeks time I can be given. I will file an application for execution malus. This auction sale notice, it was scheduled on 16th of June.
Not happened.
So that with regard to that, I have no instruction because
You don't tell it. You
only dwelling house. Bank has
property is being. You sleep in the property.
malus, I'm
Without being
still
disturbed by the auction happening.
I'm still in that property. No notice with regard to position has been given to me. Malus, with regard to this auction sale notice.
Issue.
But in this case, I am appearing for OP2, my lords, Bank of Baroda, my lords.
Why you are not consumer forum's order?
My lords, actually, after getting, since it was an expiry order, it was not, most probably it was not in our, that is, yes, my lord, that is why after getting the notice, after my learned friend served a copy on me, I have instructed my client not to proceed further, my lord, that may be recorded here. But in the meantime, my lords, two things may happen. Yes, my lords, two things, my lords, your lordship may direct for appearance of the insurance company as well as my learned, the petitioner may approach the bank with, as your lordship suggested, with the remaining amount.
Why
With the remaining,
you should come and sit on the floor of your bank. There is an order by the forum. You are not.
No, it's the payment. The remaining amount he may pay, that way it may be settled.
You have auctioned the property for entire money. You are just playing with the people.
No, that I have instructed them not to proceed further.
That instruction we don't want.
It will be settled if he approach the bank. That may be recorded, matters. My submission may be recorded.
Sure. Emergent notice. Heard the net counsel appearing for the petitioner. and also learned counsel, panel counsel appearing for the OP Bank. First now, next paragraph. Learned counsel for the petitioner draws our attention to the consumer forum order, whereby the benefit of insurance in respect of loan of the father was accorded. First off, that order has attained finality, notwithstanding that it was made ex parte. It binds. First off, till it is set aside by the known source of law, as observed by the apex court in AR 1992 SC, triple. First off. Next one. Learned counsel for the petitioner is right in telling the court that no amount could have been recovered to the extent of the liability of his father under the housing loan in question. That was taken way back in 2016, in as much as it was insured, repayment was insured. First one, be that as it may, first matter requires deeper examination, and the borrower needs to be protected from being unnecessarily harassed by the bank, which has auctioned the property, the security property on.
Not auction, my lords. Only auction notice is issued.
No auction happened.
No, my lords.
It was on 16th June.
16 June.
No, my lords.
Auction happened.
On that day, no, auction failed, my lords.
Next one, your lordship. Page 13.
On that day, auction has failed, my lords.
No, but correct. Why you gave the auction notice in respect of insured money? This is formal.
When it came to our knowledge, my lord, I have instructed them to stop, my lord.
Your knowledge is another thing. You will charge for your knowledge. That is not the point. By settling the auctioning of the security property, by showing the amount payable by the loan amount of the father also, when it is already insured, and there being a consumer forum's order. First, next one. The above being said, there is force in the submission of the panel counsel appearing for the bank that the petitioner son has to pay back has to repay to show his bona fide, since his loan is not protected by insurance. First, in the above circumstances, the coercive proceedings are hereby stayed. The proceedings for recovery of the loan in question are hereby stayed, subject to petitioner paying 50% of outstanding amount of his loan. As 15, 10. Okay. 2 weeks, 2 weeks, 2 weeks. Last, if the petitioner fails to make the payment, not only the interim protection stands evacuated, but the main matter runs the risk of dismissal on that ground alone. All after 2 weeks to show
Lords, in the meantime,
that the petitioner has made the payment of first installment.
in the meantime, my lords, no, insurance may be noticed, but insurance company may be noticed who is a party here.
Issue notice to
Opposite button 3.
OP number
3.
3. You advise your banker. This is a matter to be referred for disciplinary inquiry against the manager. Why are you harassing poor people when there is already insurance?
I will take care, my lords, about that.
Next time we may make that order.
My lord.
The next date of hearing, we will consider as to whether any disciplinary action should be directed against the bank officials. First.
Second 6, 1 6 to 19 to 20, please.
1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to 20, 20, please. 1 6 to
May my lord, the petitioner is the auction purchaser, my lord. Auction was held on my lord 5/6/2026. Sale intimation was given to me, my lord, by the annexure 2. I deposited 25% of the amount the very same day. My lord, I am drawing your lordship's attention, my lord, to clause 15 of page 12, my lord, the auction notice.
Shall notice.
Page 12.
25% you have paid.
25% I have paid on the
75% you are supposed to pay under Rule 9 or 8?
Rule 8.
Rule 8.
Yes.
Within what period?
Within a period of 3 months.
3 months.
Also, my lord, here it has been reflected, my lord. In the notice,
Clause 15.
yes, my lord. In the notice, my lord, it has also been reflected.
Tell us what they are saying.
Now, my lord, I have given them, my lord, the 2 representations, my lord, allow me 3 months time in terms of the clause 15, my lord. I will deposit the 75% amount. They sat over the matter. Yesterday, my lord, I got a mail, my lord. They have allowed me 1 month time.
1 month.
Yes, my lord. That is all, my lord.
From which day?
By 20th
1 month to be reckoned from which day?
date, my lord, that they have not stated, my lord, but
The date of this order.
from the date of this 27/2026, my lord, they have given, my lord. LRC, can you for a moment, my lord, LRC, can you? I have received the mail.
So paying of the petition before.
No, yesterday, my lord.
July 2026 will be 3 months. 3 months will expire when?
As per their past records, they have projected that 27 is मतलब 27 तक हमको चाहिए क्या
Payment करने के लिए.
करने के लिए.
The petitioner wanted to.
Yes, the 10th January, so 10th June 2026 का लेटर में.
No, when the auction,
Auction will
date
be
of auction.
5/6/2026. 2026.
26. Under Rule 8(3) or 4, what is that? What is the period prescribed?
Well, additional 90 days.
Remainder.
90 days.
90 days.
90 days.
90 days.
They have also stated, my lord, in their
With their notice also.
Yes.
Auction notice.
Yes, my lord. The 90 days period they have given.
In the event of failure to tender 25%.
Then it's
25%, my lord, 28%, my lord, I have deposited on the same day, my lord.
Your deposit.
Now that you have put it in same day.
Your lord, can you see I have also annexed that receipt, my lord.
Okay. Why, brother, why you are cutting short the statutory period?
Moment.
They are,
My lord, there is no annex of
Where there no sell intimation. Clause 15.
75% to be paid within 15 days. That
Why
is
15 days?
Average 15 days. That's because the auction notice provide the
Period.
my learned friend is right, my lord. If at all, my lord, within a period of 15 days, he cannot deposit 75%, my lord, then he has the option, my lord, to approach the bank, and my lord, that period will be, my lord, further period of 90 days will be
It
given.
is under rule
So
section.
let us read the rule. Give that.
Yes, ma'am. May
Read the rule.
to the
Which rule it is? You should always tell the title of the rules. Then go to particular rule. Then clauses of the rule. What is the title of the rules?
Interest rule 2002 section 9.
Security interest.
Yes. Time of sale, issue of sale certificate and delivery procedure. According to
Read.
section 9(4).
Read, don't argue. When you are reading, you should read.
Yes, ma'am. The balance amount of purchase price payable shall be paid by the purchaser to the authorized officer on or before the 15th day of confirmation of sale of the available property or such extended period as may be agreed upon in writing between the purchaser and the secure creditor in any case not extending the
3 months.
When the confirmation took place.
confirmation took place from the
5/6.
5/6/2026.
From
That is-
5/6, it is 15 days. Then when you applied for 3 months.
My lord, LRC, can you see annexure 2 applications, 2 representations I have given, my lord. Annexure 4 and annexure 5, my lord.
4 was given on.
Annexure 4 was given on 10/6/2026, my lord.
So it was due on 20th, but you have given it on 10th.
I have given on the 10th.
Correct. 20th, because 21st actually.
Yes, my lord. In that letter, my lord, what my lord and friend is saying, my lord, I have asked them, my lord, to grant me, my lord, time till 20th/7/2026.
20th 7.
27/2026.
Yeah.
Only
Then-
first reference.
Yes, then my lord, your lordship can see annex of 5 minutes.
Now, why is that? Kindly come to the third number paragraph in your letter. What bank says appears to be true. You have said, as per the auction terms, I was required to deposit 75% auction amount within 15 days. However, due to unforeseen medical issues of my family member, which have caused financial difficulties and affected my ability to make the payment on time. Therefore, I humbly requested to grant me an extension of 1 additional month up to date, up to
27
July.
2026.
They have given that.
Yes, my lord. On the very next day, my lord, your lordship can see annex of 5 minutes.
Another.
Yes,
And you have undertaken to make the payment also.
I have undertaken, my lord.
Yeah.
On the very next day, my lord, this letter was issued on 10/6/2026, my lord.
11/6.
Then, my lord, the next, my lord, 11/6/2026.
Now, what you said?
I have stated, my lord, in continuation of my previous letter 10/6/2026, I am said that due to the various financial constraints, I am unable to arrange 70% of the sale price to deposit the same by 26/2026. As the situation is beyond my control.
Why 26, 27?
27.
You did not know.
That 15 days period, my lord.
Right.
5/6, that is why, my lord, I have to deposit that amount within.
And requested for extension.
So, my lord, now, when earlier I had requested for extension of time till 27/2026. But now in the present circumstances, I humbly and desperately request you to kindly grant me 3 months time maximum for deposit of the balance sale price. It is pertinent to note that as per clause 15 of the sale notice dated 11/5/23, the bank is authorized to grant extension minimum for 3 months for deposit of the balance sale price. Hence, I request you to kindly consider my predicaments, allow me 3 months time as last chance to deposit the balance sale price of 62,31,000 in the.
But see, how much time should be given? This is a matter relating to banking experience and wisdom. We do not have that wisdom. Why bank will take that decision, we do not know. Right? We have seen your letter also. How can a rate court examine the decision, banking decision of the institution? It arises out of expertise, not just jail law. That is the reason why Parliament has given discretion to the bank. Where is the abuse of discretion?
No, they had not abused, my lord. I am not, my prayer is, my lord, I have my lord, my
But
prayer
your
is not that.
apprehension is also too early. See, before the first 15 days is over, you
Yes.
made a representation.
Yes.
Again, before the next 1 month is there, again you sent a letter.
Yes, my lord, 26 by
20th July is yet to come.
20, yes, my lord, 20 is after, my lord, it has to be written, my lord, after 20th of June 2026, my lord. So, my lord, he exercised, my lord, he gave the letter, my lord, that I understood, my lord, he gave the letter on 10/6.
Here, take out that judgment of the Karnataka High Court, Nitesh Estate versus so-and-so bank. In banking matter, the Royal Commission on Banking in England said the court should not interfere with the banking prudence.
So, what I pray, my lord, since because they have allowed me 27/2026, my lord.
Examine that.
So, yes, my lord. So, they have allowed me, my lord, on my first representation, they have allowed me, my lord, yesterday I got the mail. So, I am, my lord, now, my lord, I am opening this application with a liberty, my lord. If at all, my lord, any cause of action will arise, my lord, then, my lord, liberty may be given, my lord, to file application.
No, how can that be? That almost.
Then, since because, my lord, your lordship also.
Banking prudence, we don't, judges do not have that expertise.
My lord, since because, my lord, my money 28% is involved and, my lord,
We
in
do
terms
not.
of the, my lord, in terms of the
Section, the rule gives discretion to the bank.
3 months, to allow me, minimum 3 months.
Minimum, maximum thing.
Yes, my
Yeah,
lord, that period.
they have given particular period.
That period, I want to take my.
No, what are no question.
Because 3 months time, in the question of my 28%. If I do I will not deposit that amount by that time, that will be forfeited.
That will be forfeited.
So, Miller, since because 3 months time is still left with 3 Miller, and
No,
we have
left with you. Why do you say left with you?
Miller,
It's
if you-
history,
Miller-
power of the bank.
Miller, is the power of the bank, Miller. I am reading again the language, Miller.
Read.
Yes.
No, sir. Nitesh Estate,
Yes.
that judgment.
Yes.
Nitesh Estate, go to the last paragraph of that judgment.
Miller, and the balance, Miller, you can see page 12, Miller. I am
For such extended period as may
May be
be
granted by the
Agreed.
bank.
Yes.
May be.
Yes.
May
Agreed upon
be
like
renewal
between the
discretion.
secured creditor purchaser. In any case, not exceeding 3 months.
Correct. Exceeding 3 months here, an injunction by the parliament to the bank also. Merely because you have power, you can't do, therefore they have cut short that.
My lord, I will pay the remaining amount, my lord, by that, within that period, my lord. My lord, simply, my lord, here, my lord. Simply, I am withdrawing this application, my lord, for the moment now.
Withdraw.
My lord, I am withdrawing.
Petitioner having
Because it
argued the
will
matter,
maybe,
seeks leave of the court to withdraw the petitioner. with liberty to work out his remedy elsewhere in accordance with law. First one, ordered accordingly, petition is disposed of.
Milord, elsewhere milord, if the milord dismissed as suited, milord, it will sufficient. Since
No,
the-
that helps you.
No, milord, then milord, again milord, I have to approach under section 17. milord.
Liberty is given to you. That's all if you want. But
Elsewhere, we are not
elsewhere,
dealt of.
we are not saying you may go to bank also. Banking decision, Nitish Estate versus which bank?
Milord, Union Bank.
No,
Oh, your lordship has given that.
right. The Union Bank, Union of India.
Normally, milord, in any case, milord, they are allowing 3 months time.
No, we don't. We have never participated.
You will also get it, but I.
Brother also did not participate in any auction. I never participated in state in Orissa and Kaplan. Yes. We cannot interfere. It becomes a precedent for rest of the cases. That is our fear. Yes.
Publication 1876 of 2006.
May I please, Your Lordship? This is a case against the order of the London Central District Tribunal, Cuttack Bench, Cuttack, dated 25/2026, Your Lordship. Page 99, Lordship. What happened, Your Lordship? Fact is that this is a case, Lordship.
What is the prescribed qualification?
Qualification is prescribed for that is the BCA.
BCA.
BCA. I have also imposed that document that is, I passed the MCA also. MCA and BCA also equivalent to A level, Your Lordship. I have shown the documents, Your Lordship.
What is the last sentence you made?
The DOEC A level is the equivalent to BCA.
It is equivalent to BCA.
Yes, Lordship.
Who declared it?
Page 43, Your Lordship.
They have declared it.
That is the page 43. BCA is equivalent. 43, sir.
43.
BCA is equivalent to that the DOEC A level, Your Lordship.
Oh, whose certificate is this? Which institution is given?
It's not instant. Instant is given. Page 42 is that is the certificate of the DOEC level.
What is that certificate says?
DOEC level is a page
BCA is equivalent to NILIT.
that is DOEC
A
level.
is equivalent to.
Yes, sir.
No. DOEC A level is equivalent to.
Equivalent to BCA, Your Lordship. That is the page 42. I got the certificate, Your Lordship.
That certificate you have got?
Yes, sir. Yes, sir.
How the tribunal treated the matter?
Tribunal only, what happened, Your Lordship, I have solved since 2007. That is the 9 months course, Your Lordship. 9 months contractual employment, Your Lordship. And 3 months, that is the sort of holidays. And 2007 to 2026. Last is the 30th for 2026. I have annexed the documents, Your Lordship. But in the notification 26-27, that is Navodaya is issued, BCA only simply stated the BCA, Your Lordship. So when I upload in the that is the online application, when I shows my documents that the MCA and DOEC level certificates, they have not accepted, Your Lordship. So I came before the current tribunal, Your Lordship. Because 26 July, that is the first day. That is the first day, that is the continuation of the selection process. Without giving me interim order, only notice.
As on that date,
yes, Lordship.
did you have disqualification?
Yes, Lordship. I have also that post I have got in Your Lordship, kindly see. I have annexed the documents that is 2007 to 2026, Your Lordship. Last page, Your Lordship. Page.
You have done your A level.
Yes, sir. Page 65, sir. Page 65. Continue from 46. That is my appointment in the Navodaya Vidyalaya. 65. This is to certify that Lakshmi Prabhuya such and such work with their computer science teacher from 16/7/2005, 25 to 34/2026 on contract basis. Now this that the 26-27 will come. From 1st July, it will be that is the selection process going on. My application, if not there, then I could not have.
No, where have you completed that particular course?
Course, Your Lordship, prior to that, Your Lordship.
Show that.
That course is, DOEC level is 2007, that 42.
No, 42.
42, sir. DOEC level 2007, 22nd August 2007. And the MCA thereafter, Lordship. 42, sir.
Provisional certificate or 46?
Yes, sir.
A-level advanced diploma.
Yes, Lordship. That is the 22 August 2007, last
This is equivalent to
BCA.
BCA.
And I have also got the that is the Master of Science in the page 44 and Master of Computer Application in 45, MC.
Issue. Who are your opponent?
Navodaya Vidyalaya.
Central it will appear. Central government.
Navodaya Vidyalaya.
Issue notice. Issue emergent notice. OP number 1. Learned DG is requested to accept notice for OP number 2. Deputy Commissioner, Mr. Beura,
My lord.
you appear for Deputy Commissioner. Navodaya.
No, my lord.
You are appearing. That no, both for Deputy Commissioner also.
Yes.
Mr. Pari will have it, yes. On the question of support is 1, 2, 3. Matter lies in the narrow compass, all the same. In the third week of July, for consideration of interim prayer.
Item 8. Notification 189.
Give copies to Mr. Pari.
Yes, sir.
Item 8. Notification 189.
Yes, yes, sir.
May I please, Lordship? Here is a transfer matter, Lordship. A person, senior officer, has been transferred in gross violation of their own guidelines, Lordship. And second, Lordship, to a lower post, which, Lordship, affects my Lordship, dignity of a person, Lordship. Lordship, I want to demonstrate 2 things, Lordship, kindly see.
Order, you went to CIT first.
Lordship.
What CIT said on these aspects?
Lordship, they have not examined, Lordship, only says, Lordship, this is condition of service and relying upon the judgments that I have to transfer. But these 2 aspects have never been considered, Lordship.
What are those 2 aspects?
2 aspects, Lordship, can state come to Lordship, Annexure 1, Annexure 2 series. I have given their own guidelines, Lordship, more especially page 24. This is the notification of 2/2010, Lordship, page 24 of the brief.
This is spousal transfer.
Lordship.
Spousal transfer.
No.
Husband and wife transfer.
No, then, yes, Lordship, we are staying at Puri, Lordship, both wife and husband.
How long you have been there?
They are, Lordship.
Answer the question.
Lordship, more than 10 years, Lordship.
More than 10 years.
10 years, Lordship.
More than this.
More than 10 years.
More than 10 can be 20 years also.
No.
How long?
No.
24 years, 8 months in Puri. 4 years into Maruti Patpur is only 8 kilometers.
No.
I think this employee has a ego now.
No.
I have to stay in Puri.
But don't make a certain statement that my case will be affected.
It transferred to which place?
Lordship,
Maruti Patpur.
no, it the entire submission, my Lordship. Lordship, kindly come to state, Lordship, come
What is that?
Annexure 3. Lordship, kindly come to page Annexure 3, Lordship.
How many years?
From the
How many years?
It is,
In Puri, how many years?
I'm just, for Puri, initially he was on 12/1/2004 to 2010, 8 years.
12,002 to 2012.
10, yes.
12.
Page 24. Appendix 3. Then he has for 1 year, 8 months he has in Bhubaneswar railway station. Again he has from 2011 to 2018 in Maruti Patpur at Puri.
11 to 18.
Then up to again yet up to 2026 in Puri, Maruti Patpur.
Transfer order is
Patpur and to Puri now is one station. This some station are leaving from Maruti Patpur, some station are leaving from Puri. The expanding station now.
The transfer order is dated?
This is transport at
21/4.
a common transport, yes.
21/4.
5,
21/4.
21/4/2026.
What do you say about his transfer to a lower post?
Lordship.
It is not a
It's not a
category, yes. Category station, they have posted. Yes,
What is he working at? What is he working at? He is working as? He wants to have a house beside Lord Jagannath's temple. Bro.
That is not the case, Lordship. In fact, Lordship, only to Lordship not to give further promotion. It is a great conspiracy by the officials. Lordship, kindly come to Annexure 3.
What is your designation?
Lordship, I am station supervisor, Lordship.
Lordship, kindly come to Annex 3 for a moment. How they have degraded my position, Lordship, kindly see. I want to demonstrate only that only, Lordship.
1 second.
Lordship.
Your station supervisor.
Station supervisor.
Railways? No.
Railway.
Station supervisor. What is your, in what pay scale you are trying your salary?
That information I don't have.
Then how can you say that going to the lower post? Read 74 Supreme Court. But the royal.
Lordship, kindly come to Annex 3, Lordship, for a moment. Annex 3, Lordship, for a moment.
We are there.
Page 28.
We are asking you,
Lordship.
are you reduced in your rank or are you posted to a post who is lower in rank?
Yes, sir. That I want to demonstrate, Lordship. Lordship, kindly come to page 28.
Yeah.
Lordship, this is just notification by the central government categorizing these railway stations, Lordship. Lordship, kindly come to their category, that is NSG 1 to NSG 6, Lordship. And Lordship, NSG 2, Lordship, I want to demonstrate no two category for Lordship. That is NSG 2, Lordship, kindly say page 28.
This categorization for what purpose?
This for Lordship, the criteria categorization have been revised, Lordship. This is for Lordship, the categorization of the station as per their category, Lordship.
What purpose? It's depending upon footfalls and the passenger strength.
Lordship, investment, Lordship, that they are saying, Lordship, investment and Lordship, standard of station, Lordship.
How you are concerned?
Lordship,
It's a business matter.
no, Lordship, but they are, Lordship, they are sending to a post, Lordship, where is no only a passing station. If only, Lordship, not to give further promotion, if I will go there, Lordship, my junior will promoted here, I will be there, Lordship. That is
you can challenge, not this.
Lordship,
When it happens, you can challenge.
Lordship, kindly bear with me 1 minute, Lordship. Lordship, kindly bear, Lordship, because Lordship, with a great hope I have come, Lordship.
So many people have hope in the life.
Definitely, Lordship. I'll try my best till Lordship passes some order, Lordship. Lordship, kindly come to. Then Lordship, kindly come to the next 2 pages I have annexed. Page 30. Page 30, Lordship, Puri station comes under NSG 2 and this Maltipatapur comes under category NSG 6. It is only, Lordship, is a passing station, Lordship. There is no requirement of Lordship any staffs.
But they know where to post whom. How can Brother Das and the Justice Dixit decide?
No, that's why I'm giving emphasis on their own notification. If their notifications say both the wife and husband will stay in one unit, one station, Lordship, how can they disturb their own guideline? That is
how you are posted to which place?
That is Maltipatapur.
Only the.
Don't say that is 2 unit, let's see.
No, what's the distance?
Don't say means this is my case.
It is a case that the Puri is a Puri is Maltipatpur, another is Puri. Some train are leaving from Puri, some station. My Lord, train knows.
No. You are giving a wrong statement. It is a station on the way, Lordship. Only it passes through the station. Lordship, kindly see my position. I am a station supervisor. Lordship, can I work?
What is the distance we are at?
Distance, Lordship. I don't dispute. I don't dispute, Lordship. That is Lordship. Lordship,
where is the hardship?
Hardship is my position, Lordship. I am not.
Your position is not. We will make it clear. Your position is not affected by that.
That is affected, Lordship.
We will make it clear.
Lordship will not serve that.
We will protect that.
Lordship,
will give protection.
Lordship, kindly see other conditions, Lordship. My wife is suffering serious gynec problems, Lordship.
What?
Gynec problems, Lordship. So, Lordship, can I, Lordship, kindly see one thing, Lordship. It can be, Lordship, accommodated, Lordship, because that it is the officer's ego, not Lordship. It is not a concern.
No, ego.
It is not my ego, Lordship.
How long you can stay in one place? It is for the management to decide. Where
others are continuing there. Same standard of Lordship, they are continuing there. Other officers, Lordship, with same Lordship, status, Lordship, they are continuing. But it is Lordship, kindly, in long run, I will suffer, Lordship. Why, Lordship? Because Lordship are there, sometime, Lordship, perhaps there is nobody to rescue my purpose, Lordship, because I will not be promoted. Because Lordship,
that you will not be promoted because you have been posted somewhere.
Because they have arranged and Lordship, if I transfer to the Lordship Maltipatapur,
it doesn't do that.
My senior to Lordship. Because Lordship, the next post is station.
That you say only, you justify how you say.
Seniority is a unit for the seniority is what? What is the basis of seniority? What is the unit for seniority?
Is it on the basis of posting? No.
Seniority could you categorize in a particular person who is in a particular pool to another?
Correct. Not
here he has a transfer as a SS Puri to SS Maltipatpur.
And the same
post.
And seniority is not affected.
No, senior will be affected. Lordship.
So your record is sufficient. Your seniority will not be affected by posting. Over.
But Lordship, then what to be Annexure 2 series, Lordship? There is no notification.
Dismissed.
Lordship, Annexure 2 notification.
Yeah.
Lordship, instead of dismiss, Lordship say, because it transfer matter, Lordship. Lordship, it is the discretion of the authorities, Lordship. Can they reconsider, Lordship? I will approach before them, Lordship.
No, he will not permit you. Because how long he can remain there?
Lordship,
Permanently
all are continuing their
That
Lordship.
makes no sense because management knows which employee should be posted where. It is managed employer's prerogative. How can court interfere?
No, I'm not saying
It is wrong.
I am not saying to court to give you any opinion, Lordship. Your Lordship only saying I will approach them. They'll take a decision, Lordship.
Then
Because-
if you withdraw, we will give that liberty to you. Not otherwise. If you argue, it's over.
No, Lordship, it is a transfer matter. I can't argue on point of law.
That's
Lordship.
what. That's
It is
what.
discussion of where can.
Shilpi Bose and Abbas.
Lordship,
That is considered.
that's why Lordship only say, Lordship, I will approach them. They'll take a lenient view, Lordship, to that.
If an employee, railway employee, transferred from one place to another with a distance of less than 10 kilometers is knocking at the doors of Red Court for assailing the central administrative.
Lordship, I approach them. No,
He protects the order dated so and so, whereby his OA number so and so challenging the transfer has been negative. Personal. Next paragraph. The learned counsel appearing for the petitioner vehemently argues that the transfer is bona fide, semicolon. The transfer is to a post lower than what the petitioner has been holding all through, semicolon. Petitioner's wife is suffering from acute gynecological problems
and also working there.
who is also working in Puri
Unit, that is it.
and therefore his proximity to the spouse is inevitable. First, he also tells that the transfer guidelines have been violated and this aspect having not been properly examined by the tribunal, there is error apparent on the face of its order, warranting interference of this court. Prashna, kindly be seated. Please be seated. Learned DSG, assisted by learned CGC so and so,
Senior Bank Counsel,
so and so, vehemently opposes the transfer, contending that the transfer is an incidence of service in the light of decision of the apex court in Varadhara versus State of Karnataka, and therefore courts are not supposed to interfere, especially when the employer's prerogative has been exercised, taking into account all relevant factors. First, he also tells us that during the period between 2002 and 2010, the petitioner was working in Puri only, and thereafter again from 2011 to 2018, he has been posted at Puri itself. Even presently, he has been working in the said place, and therefore he cannot squat at the same place throughout his service. First off, having heard learned counsel for the parties and having perused the petition papers, we are not inclined to grant indulgence in the matter, in as much as the tribunal has considered all aspects of the matter and arrived at a just decision. First off, that apart, the contention of the petitioner that his status as such is affected by the impugned order is not demonstrated despite vociferous submissions. First off, how status is affected has to be demonstrated by cogent material on the well-established principles of jurisprudence, needs to be hardly needs to be stated. First off, next paragraph. The vehement submission of learned counsel for the petitioner that because of this transfer order, his seniority and ranking are affected, and therefore that would diminish the promotional chances is bit difficult to countenance when there is a specific assurance by the DSG that such things are not happening. Some things will not be done. Will not be done to any employee, much less the petitioner here. First, the next point, the last submission of counsel for the petitioner, the next contention of counsel for the petitioner, that there are many other candidates who have been in the same place far longer than the petitioner, would not come to his aid. First, ordinarily, it is the employer who decides which employee should be posted where, and that would fall within the domain of employer's prerogative, which courts would not readily interfere with. First, in the above circumstances, broadly agreeing with the submission of the DSG, this petition is disposed of. Okay.
Good.
Item 9.
Sir, I permitted to join, so I have to see.
Let him join. Petitioner to join to the post pursuant to the transfer order within a period of 1 week.
Let's
1 week.
get.
And if he joins, no discipline reaction or the kind shall be instituted against him.
Grateful. Grateful.
Item 9, contains to what is government of 2026.
May I please, your lord?
Item 9, your lordship, we have filed an SLP and his diary number is 26518 of 2026, your lordship.
When you had filed, give the date on which you have filed. And there also delay.
30th of April.
Yes, your lordship. That
When
has-
we had issued notice.
Yes, your lordship, it had already been filed, but we are awaiting the reopening of Honorable Apex Court for
On
a
30th,
listing.
court is reopening.
Yes, your lordship, after
We'll
that.
call
we-
this on 22nd, 23rd.
Lordship,
23rd of July.
yes, first, your lordship.
May issue notice, sir.
Time for me
Subject
to
to
please-
result of the SLP, your lordship may issue notice.
No, Madam PS, no. He's saying that the SLP is filed anyway. We'll call it
Mid of
the first
August,
week.
your lordship, 3 to 4 weeks, mid of August.
issue notice. First off, Madam AGA accepts notice for the contemners on instructions and submits that SLP has been preferred against the order whose violation is complained of in this case, and therefore a short accommodation be granted, keeping in view the vacation for the apex court, vacation period of the apex court. First one. Next one, in view of the above, call this matter into one date in August. No, 5th of August.
Same, both are same, 9, 10.
9, 10, same.
10th is
New case, first time it is
first time it is.
different case.
Police notice. Returnable within 2 weeks, call it on. Yes. That is, say the again, you put notice last column. It should be note of warning. Note of warning.
In one matter, it is there.
They have said,
Kindly evaluate.
you have done it now. You different people
What?
take the dictation, therefore formats are again being changed.
Note of person is there.
Note of caution, it should be. Yes.
11 has been adjourned. Item 2A.
Dear Lord Silvata.
Wait to.
I have.
Twelve and 15, same.
Same.
Krishna Chandra Malik.
Welcome.
Your lordship's
We have that. What's that?
Now, I have the extra copy.
You know that. We'll bring this order, same order. This order, was single judges order, judges, passing to the number, so and so.
15-7.
And is also understood. Then so it's the science from we have 154 degrees. It has. We'll condone it. Why not? We have done that already.
Lord, 15 is also same.
Short delay, plausible explanation in offer. Therefore, application is favors, application property affidavit is favors, delay of community is condoned. Then, other things are instruction 12 and 15. 901 days delay, that will not condone. 15, delay is too long, the explanation offered is not plausible. Therefore, application and so last, the appeal is dismissed both on the ground of on merits and legal. Okay.
Item 13, make a petition for 9/5/2024.
But this is a case, my lord.
13, my lord.
Identical order, my lord, has already been implemented after the finalization in the SLP, my lord.
My lord, may I please? This is in respect of the RSCP matter, ma'am. Series of matters are pending before the Hon'Ble Apex Court. And it is fixed to 8/8/2026, my lord.
8/8?
Yes, ma'am.
We call it after.
No, that is separate, my lord.
No, my lord, the same issue.
They are, my lord, and they are saying that this case is.
And the order which is relying upon
due to pendant
by my
case,
learned
we are not
friend,
implementing the order.
this is in the point of only ground of delay, my lord. So far merit is concerned, it has been around 500 matters are pending.
My lord,
It is
what-
fixed to
my lord,
8/8.
My lord, what has happened, my lord? My lord, tribunal. My lord, tribunal has allowed the case, my lord. My lord, tribunal has allowed the case, my lord. They didn't challenge this, my lord. So thereafter, I approached before the Hon'Ble High Court, this court, my lord.
No, similar matters are pending.
My lord,
Matter is now on 30.
8/8, my lord.
8/8.
Because
All this
my
matter
lord, two SLP has already disposed of, my lord.
solid. Let us.
only on the ground of delay, my lord, not that on merit. But merit, it was
has taken it on merit. What has
Yes,
it of merit in
it was in merit, my lord. And posted to August.
Do you have a copy of that order?
I have copy, but I cannot download it. I can.
My lord, only point is that my lord, they have granted the grade pay, my lord, with effect from 1/1/2013, and then 1/1/2013, then 3/1/2013, they reduced that after granting the benefit, my lord.
They withdrew that.
My lord. So once the higher scale of pay has been granted, my lord, so that cannot be.
Once it is wrongly granted,
My lord,
if it is wrongly granted,
not wrongly, my lord.
that you have to show.
My lord.
Whether it is rightly granted or wrongly granted, that has to be demonstrated. Therefore, matter requires deeper consideration, especially when matter is pending before the apex court. So we'll call this matter in the third week of August 2023 at the request of learned EGA, who submits that identical matters are being examined on the floor of the apex court on 8/8/2026.
Item 14, need a please forward to 2025.
My lords, I'm appearing on behalf of the respondents. My lords, the conducting counsel's father suddenly fell ill, so he had to rush to the hospital. My lords, I pray the matter be taken up tomorrow, day after tomorrow, as per your lordship's convenience.
Adjournment to you. All right, call after 3 weeks. Yes.
Item 15 has been disposed of. Item 16, review petition 71/2023.
And this is a batch of matters.
Yes.
Your lordship may kindly take up the last matter because that was the leading matter in the writ, considered by the writ.
103.
My lord.
Yes, what is wrong with this?
Milord, I'm conscious that the review, Milord, scope is very limited. Here, Milord, my specific.
Thank you.
Milord, Milord, here my scope is, my humble submission that they have committed some fraud on code. Therefore, this outcome, Milord, of dismissal order was passed, Milord. It is my specific stand that your lordship kindly turn to the order, Milord. Kindly, annexure 1 is the honorable
Yes, order is
bench
there.
order. Your lordship may kindly turn to paragraph Milord, 10. Para 8, your lordship may kindly. Para 8. May I please, Milord? Para 8, Milord, kindly see.
By our decision or some other court?
Honorable Justice. Yes. Milord, kindly turn to page 28. Milord, page 28, paragraph 8. Only 2 paragraphs I will place. Then, Milord, when the matter was first taken up on 11/9/2024, a submission was made on behalf of the Learned Council for the petitioners that though the decision rendered by the Learned Central Administrative Tribunal, Cuttack Bench, Cuttack, OA number such and such, it was the employees of the NWDA are to be governed by the CPF rules 1982 and not contributory from a Provident Fund rules 1962. But NWDA has not framed any CPF rules 1982 and as such a rule is not in existence and therefore the petitioners are to be governed by the CPF rule 1962. And accordingly, we ask for specific instruction to obtain to whether there is any such rules, namely National Water Development Agency Contributory Fund Rules 1982 or not. And if it is existence, produce the copy of that. Then your lordship may kindly turn to paragraph 10.
There is a delay. First, delay. Thereafter.
No, but he has to convince on merits also.
Yes, sir.
For condoning delay.
Your lordship may kindly see the paragraph 10. Therefore,
in view of
the CPF rules 1982 produced before this court by the learned DSI, so also the observation of the Honorable Supreme Court such and such, we are not inclined to accept the submission made by the Learned Council for the petitioner that NWDA has not framed the NWDA CPF rules 1980. Then my case was dismissed.
Then there are rules or not in the question.
Yes. My humble submission, there is no such rules. In this review application, I have taken the specific stand that by way of fraud, they are defrauding us to get the pensionary benefit.
Where are the rules?
Here there is a, just which all the records have been taken. There is a rule on. This rule is there. That is the rule on of the CPF rules.
Give that copy. Just file the copy. We'll give copy to him and we'll send him home.
Yes, let's make it some other day.
Why some other day for showing rule?
No, all the documents we have produced with the court.
Don't worry about production. Their rules can be their instruments.
Monday, let's keep it Monday or Tuesday. Tuesday.
At the request of the DSP, where the taken produce copy of the.
Thousands are waiting ballot for pension. So in this rule, they are depriving us. Thousands of families in the NWD.
My lord, Tuesday.
One prayer. Another matter. This batch matter. Another matter, my lord. That diary number that has been given. I'm giving in writing.
Yes, call only.
Item 17, WBC 407, 36 of 2021.
and he is appearing in person. So let's say my lord directed me to have a discussion with the officials and something outcome will come up. Then only it can be started up.
Unauthorizedly remaining absent for 22 and a half years. Yes, we have put in how many years of service, sir?
28 years of
28 years of service. He has put in.
Taking into all this consideration, my lord asked me whether you take instruction from the official.
We wanted to levy heavy cost for harassing an employee who has worked for 28 years.
My lord, there is a lot of
Ego trips has been taken. Ego trip. It's a case of ego trip. Ego has to go. Then justice happens.
Technically not issue. See, now a thing is this: the person who is unauthorizedly absent and he has submitted application which was not accepted, till then he is continuing unauthorizedly or
22 and a half days.
service. But the punishment is regard to dismissal. I am agree with my lord that it is a measure.
What kind of harassment to an employee? What kind of message it? Even East India Company did not do it to its employees like this. You are a welfare state. How can we do all this? Even if 1 day is given for each completed year, he will be entitled to 28 years.
Another aspect is that because the long period of absence, if you will consider this and the entire financial burden come to the government.
No, but we also wanted to know that time if he was in the habit of doing this.
Did he ever do that? This is one single. It's a Shakespeare said, one single swallow makes not the summer. That applies here. If one sparrow comes, will you say a sparrow that, oh, summer has come? No.
My lord, they remove.
Although it is attributed to Aristotle. One single swallow makes not the summer. This is one such case. Only once, 28 and a half years he has put in service. First time he remains assuming unauthorizedly absent for 22 and a half days. What is that all? Railway employee?
Station master
come to a standstill.
What they are saying, this station master is very responsible post. Once he is absent unauthorizedly, there is a other. If it is not a general duty like this, it's absence of station master, then many things will happen. So somebody should this.
My lord, I am not a station master. I am chief office superintendent.
My lord, misleading that he was not be very happy.
No, not knowing about it. He was superintendent.
Another case I will do. Yes. So, Lakshmi, last occasion, my lord is giving me a suggestion. So, we have wrote a letter to them. I don't get any public response.
They will not get because they are taking ego trip. They are on scope. That's the reason. This is not the way that employee should do.
My lord, there is no misconduct, my lord. There is a RIT advice which I may kindly be permitted to read. This is RIT advice that is in the year 2013. They removed me in the year 2012.
Punishment was reduced. Compulsion was given.
For compulsory? For this compulsory retirement? This is on what ground?
Punishment reduced to the extent that he is given a retirement which...
No, he does not want that.
No misconduct is there. That portion I am just reading.
My lord, could have understood
what I am submitting, my lord. Last occasion also, my lord has taken cognizance of this. This also,
you tell how much cost should be used.
That part I am paying my lord. That's a no.
They may do it to other employees.
It is not a personal to any employee, my lord. It is not a personal to any employee or any working system.
Mr. Padi, you have seen that Sahu judgment. When compulsory retirement can be ordered, and it has been approved by the Apex Court, and the Apex Court went one step further, giving him full salary.
Well, Lakshmi, we are not given. I am that's why seeing Lakshmi, another case. One station master was absent.
No, but that's not the case. Station master, we understand. It's a very pivotal post in the railway system. Havoc may happen. We understand. But what about the Supreme Court? We have put in 28 and a half years of long, spotless service. And you send him home only. How? Ununderstandable. Where is the element of justice in your orders? Your order should be pregnant with human elements. And you have seen that Bhupendranath Hazarika versus State of Assam. The court said the human element, you cannot treat the employee with an unfair element. You are a model employer. Hazarika says the state is a model employer. Any entity under Article 12 is a model employer. And railways is a model employer. You are central government. Cost you have to argue. Therefore, we adjust the matter other day. How much cost?
Pass an order. You only took adjournment.
How many more years of service you have got?
My lord, 7 years of service was left by that time.
No, now.
My lord, now my superannuation debt has already been expired from 31/10/2019. Now I am 66 years old. My lord, from the last August 2012 until date, I am not receiving any salary, any pension, etc. Last 14 years, I am without any payment from the railway.
No salary is paid.
No.
Salary will not be paid because you
my lord, salary, they are to pay salary up to my superannuation from the rate of from the date when they removed me because my lord, I am a disabled person. And when they removed me, at that time I was under treatment at SB Niktar Molatpur Kotak, duly referred by Railway Medical Authority. And at that time, without giving me inquiry report, they terminated my service. Before submission of statutory appeal, they upheld my punishment appellate authority. Again, I went to
tribunal change.
My lord, before tribunal, I came to State Commissioner after the departmental appeals were completed.
What is the order of the tribunal?
Tribunal may not upheld the order of.
Actually, because sufficient opportunity has been provided, in spite of this, he has not accepted the same and not
for the proportionality of the punishment.
It is the doctrine of proportionality, 2006 Supreme Court. Where is the treatment by the tribunal? Though ordinarily the punishment lies in the domain of the competent authority, but that will not make him a Mughal.
My lord, before coming to tribunal, the matter was dealt by High Court Honorable High Court Single Bench, and High Court Single Bench remanded the matter to the State Commissioner for Persons with Disabilities to pass the order on merit. And High Court also observed in para 7 of their order that all the departmental authorities, they did not deal with the matter properly. There is a specific observation. For that reason, they challenge railway challenged the order of a High Court Single Bench before in terms of a writ appeal before the division bench of the school. And finally, that writ appeal was closed without any order. And I came
without order.
That means that was treated as influxus. And then I challenged when the Disability Commission stated that compulsory retirement is also not valid in law, and directed General Manager again to pass order. But General Manager again imposed the compulsory retirement without challenging the order of a Disability Commission, for which I submitted a review petition.
So, Mr. Paddy, if it is a compulsory retirement, how he is not receiving any
pension is also not paid.
He is supposed to.
My lord, no, my lord, I am not getting any pension.
That is
because my lord,
for a moment, Lakshmi see page 2 to 8.
My lord, I have not. They are claiming
explain everything.
My lord, they are saying that I should fill up all the forms. Because my lord, they terminated my service when I was under a hospital leave, that is government leave. For treatment I was undergoing because I am standing with the artificial limb, and that in course of employment I lost my right leg below knee and became a disabled person.
Sit down and argue.
No, my lord, I am comfortable. No, my lord, I am comfortable standing. And since during the course of my employment I lost my right leg, whenever the replacement of artificial limb is required, that period will be treated as a hospital leave. And when they removed my service, I was under treatment at a hospital. without giving inquiry report. Till today, they have not given me inquiry report, my lord. And when Disability Commission passed order, they did not implement, nor also they challenged the order of Disability Commission, which repeats finally.
When your leg below knee was amputated?
In the year 1999.
Was it in the course of employment?
Yes, my lord. At that time, I was a station master, deputy station superintendent. That was in course of employment. Yes, my lord.
No, during employment.
During duty, I lost my right leg.
During duty means, is it out of employment or is it only in the course of employment?
In course of employment, for which I also received a compensation under Workers' Compensation Act.
So it is in course of and out of employment.
On duty, yes, my lord.
No, on duty, all right. If duty, suppose when you are sitting in the office, some snake bites.
No, my lord. At that time, I was a station master. Yes, my lord.
You met with an accident?
Yes, my lord. I was directed for duty to Sambalpur when I was returning by 10. And during night time, when I was getting down from 10, at that time 10 started and my leg was crossed and severe injury was made.
It was accidental, railway accident.
Railway accident. Yes,
employees.
But due to my, when I became disabled, they have to protect my service till my retirement. But my lord, they terminated my service during when I was undergoing treatment.
Yeah, that's do you dispute amputation, brother? Because under the Railway Accident Claims Act.
Yeah, Mr.
Not under employees.
No, my lord, I have already
got the compensation.
Yes, my lord. That matter was decided in the year 2000 at that time.
Have you pleaded that in your papers? Sit down.
No, my lord. Then I was medically deputized and I posted as office superintendent. I performed office superintendent from 2000 to 2000.
1 second, just give us the foundational facts.
Yes,
you gained entry to the service as what?
I was appointed as an assistant station master in the year 1984, my lord.
1 second. Assistant. Yes, sir.
My lord, in the date chart and written note of submission, I have mentioned everything.
You have that?
Yes, my lord, available in the file.
Go to the date chart.
Date chart and written note of submission, detailed explanation is there, my lord.
1 second. You were employed as the AS.
Yes, my lord. And on 16/4/1984.
16/4/1984.
Yes, my lord.
Yeah.
Then I was promoted to the post of a deputy station superintendent in the year 9/12/1999. 99.
Deputy
station superintendent is my lord. After performing about 15 years of service.
Yes.
And at that time, I met with an accident on train on duty and my leg was amputated. And I, from 2000 onwards, at that period, at that time, my lord, that period was also treated as a hospital leave, not debited from my leave.
TSM to office superintendent.
Office superintendent, my lord, alternative appointment.
Yeah.
And after appointment, I performed satisfactory duty and also promoted from office superintendent to chief office superintendent in the year 2003.
Yeah.
And when I was undergoing in the year 2008, they transferred me to Titlagarh from Sambalpur to divisional office to Titlagarh. My lord, that order I challenged in the CHITTARANJAN, and CHITTARANJAN in the Honorable Central Administrative Tribunal directed to reconsider my retention at Sambalpur. But they did not obey that, and for which I came to this honorable court, and the division bench of this honorable court stayed my transfer, and that case ended in the year 2021, whereas my service ended in 2019. An entire period stay was given, but they were not giving me any duty, my lord. When I was working as chief office superintendent, they kept me idle for 4 years. And when I was taking leave, they refused my leave. And and on the pretext of unauthorized absence, they terminated my service. And from 2012 till today, I am struggling from one court to another. said, I have received a favorable order from Honorable High Court single bench. My lord, I may be permitted to read the Honorable High Court single bench observation in para 7 of the order. My lord, may I read?
Yeah.
Para 7. My lord, read petition page number 142. Para 7. Considering the rival contentions of the parties, this court finds though the writ petition involves the disciplinary authority, the appellate authority, the revisionary authority, and also the other higher level subsequent to the disposal of the revision and review, but for the petitioner's approach against the order of a punishment and a reduction and a confirmation thereof by the higher authorities to the State Commissioner of Orissa Bhubaneswar under the provisions of PWD Act referred to here in above, and in the decision of the State Commissioner Orissa Bhubaneswar at Annex 30, this court finds there is no adjudication of the proceeding involving the petitioner as of now by any competent authority, except the State Commissioner deciding that the proceeding initiated involving the disciplinary proceeding concerning the petitioner was not maintainable before the State Commissioner under the PWD Act, and leaving it open to the petitioner to approach the competent authority. The question needs here to be decided whether the petitioner, for the involvement of the petitioner, a particular issue had a remedy to approach the State Commissioner under PWD Act 1995. Lastly, my lord, Honorable Single Bench directed, remanded the matter to State Commissioners for persons with disabilities.
The commission said what?
Commissioner said that the imposition of a compulsory retirement is not valid in law.
Where is that?
Just madam.
Whether that person who imposed the punishment, is he still in service?
No, my lord. Two general managers, they passed order. One passed order after receipt of RRT advice. That is, he passed order on 2013. Retired on 31st/8/2013. Another GM, after receipt of State Commissioner for Persons with a Disability order, he passed order on 16/11/2018 and retired on 30th/11/2018. Just before retirement, even my lord, the second GM who passed the order, that his order came to me after his retirement. I received his order on 5th, and he has made a party in this case also by name. That Umesh Singh, general manager, has been made a party.
Personal party.
Yes, my lord. And from 13, the RRT, when the RRT, just my lord, I am reading the Disability Commission order after receipt of 173.
Relevant portion, recommendation you read.
My lord, just
page number
173, read petition. 173. Be that it may. 173. Be that as it may, it appears prima facie that the observations given by the RRT to come to the conclusion that the punishment of removal from service was not valid in law were not strictly adhered to by GM in as much as irregularities committed by you, inquiry officer, my lord, and appellate authority, as pointed out by RRT.
Removal is not valid.
My lord?
Removal is not valid. That's what
my lord, RRT state removal is not valid. There was no recommendation for reduction of the punishment. That means RRT advice, just my lord, I will go RRT advice, which is very clear, very much clear. Page number 115, my lord.
115?
Yes, my lord. That is clear. And that is based on the recommendation of Supreme Court, Honorable Supreme Court judgment in the case of Krishnagandhi Parmar versus Union of India. And para 16 to 19, they have a question. Just my lord, I am reading. 115, my lord. We have carefully perused the charge memorandum, the oral documentary evidence, the report of inquiry officer, reply of CO, order passed by DA, AA, grounds of appeal and also revision. In this case, the CO was charged for unauthorized absence from duty amounts to failure of devotion to duty and behavior unbecoming of a railway servant. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different reasons due to which an employee may absent from duty, including compelling circumstances beyond his control, like his illness or illness of.
The absence from duty was not willful.
Yes, my lord. They finally wanted the absent was not willful, and finally stated that, my lord, all were there is not a single adverse against me in their report, my lord. All the recommendations, they are from para 16 to para 19 of Kushnath Parmar case, decided by Supreme Court in the year 2012, my lord. And I have enclosed all the judgments in my case as per order of a previous bench, my lord, honorable bench, my lord.
What is this, Mr.? He went to attend to his ailing mother for 2.5 days. And Valmiki writes.
My lord, still application they refused, my lord.
See, he went to attend to his mother, ailing mother. And what is our tradition?
I'm not contradicting or disputing anything. What is it?
What kind of difference?
But thing is this: in the time of inquiry, for a moment, let's see, page 92 onwards.
In
93 is very.
In Ramayana, there is a shloka. Janani Janma Bhumischa Swargada Vigariyas.
Yes.
What is meant by that? It is for chanting.
But
He went to attend to Janani.
person who is working, he has a social responsibility.
For 2.5 days.
To discharge the responsibility as well as the responsibility to the family. Buddhi should be taken
Mother,
care.
Janani
What he has
Janma
done-
Bhumi. Both are, they are higher than
everything.
It's heaven. He went to attend to his ailing mother.
There is no dispute to that. What happened in inquiry report? Let's see for a moment. Page 93.
Yes.
Just let's me come to the X.
That is
13. That is
point
13.
of the court.
Roman 13. In force of, may I read? That is in page 92.
Yes.
In course of inquiry, apart from the preliminary DNA inquiry, sitting in which certain inputs of yes, presently I removed for regular then removed sitting and there is a case for despite receiving the inquiry for the same. This was forced to completely expert. Then let's may come to the XX.
Page 93.
Page 93.
During the course of inquiry, total cities, conducted, attaining that only one city, unfortunately, people this place the best is what
Yes.
Yes.
Then
He was insubordinate and little arrogant. These are your.
My lord, these you are not.
may come to the revision order one page.
My lord, the punishment which is imposed, that is not in the charge memorandum. Charge memorandum is only 22.5 days of unauthorized absence. And my lord, prior to this alleged unauthorized absence, 1 year, and after me joining, 3 years, I was kept idle in the office because of my transfer order stayed by Honorable High Court, and I was not given any duty for 4 years. Continuous 4 years from the year 2008 to 2012. And in that case, marking unauthorized absence and terminated by service was totally illegal on the part of the railway administration.
Only on another two things I have just to say. This page 120, because Lordship is rising, page 120, the tribunal, then tribunal's order under 225. This order shows that in no point of time he has extended his cooperation, neither in nor extending his cooperation for the anything. Authorities are trying their best to accommodate and to help them. It's not because of the arrogance, is not extended any cooperation to that.
That's all right.
This come to this extent.
There appears to be some recalcitrant attitude on this part also. We don't say, because persons who do not obey the higher ups will create lot many problems in the organization itself. We understand that.
Yes.
But question is, for the 28.5 days absence.
Yes, sir. Then I leave to the court, my lord. I will not.
My lord,
the conduct of this petitioner is not.
My lord, something which is objectionable from your part also. You did not.
My lord, I was not attending because the inquiry officer who is recommended for initiation of disciplinary proceeding against me, that person was appointed an inquiry officer. And when I was undergoing treatment, my application for change of
you should have only make a representation. Stating this fact, and he could have.
New person has come.
It happens in many cases.
No, my lord. They did not. For that reason, the matter was.
We see some recalcitrant attitude from your side also.
No, my lord.
Waging the wars against.
No, my lord. These are all.
That is also there. That is also.
Page 120 and 121 are similar.
Otherwise, how the organization will run?
Yes.
We cannot run the organization.
1890,
some hierarchical discipline we have to follow. Whether we
my lord, I was not attending inquiry because of my own fault. Because my application for change of a replacement of inquiry officer was pending. My lord, that was pending with the chief operations manager, and that was decided when I was undergoing treatment at Olotpur. And that
they changed the inquiry officer.
No, my lord, and subsequently the inquiry report. My lord, subsequently inquiry report they did not communicate me till today. That is the problem. Under 10(2) of RSDA rules, they are bound to communicate me inquiry report. They have not communicated me inquiry report today.
Let us see. Third result. Maybe tomorrow day after the first year.
I don't.
They were saying, we'll sit down there. When you come at 2.
Yes.
Just before I take your lordship to the foundational facts, the last order.
Yes,
last order.
2, 3 children. What my brother was saying. My brother comes up reading the papers. Unlike me, I do not much read. Just I glance there.
I am not going to take your lordship to any of the facts. I limit it only to the pure question of law. Pure question of law. Your lordship would see last order. The lordship said, call this matter on 24/6/26 at the request of the learned AGS Mr. Mahanti, appearing correspondent final. Now, Lord, I request your lordship to flip over to the disqualification order.
Yes.
That is at page.
Can you say very brief facts?
Right. The petitioner was elected as the chairman from the
Gram Panchayat.
No, not Gram Panchayat, cooperative society.
Cooperative society.
From the cooperative society, primary cooperative society, he was nominated or elected as the chairman of the apex body. Now, while he was continuing as such,
It's a two-tier or three-tier system?
it's a three-tier system. In fact, primary, then central, then apex. While he was continuing as the chairman, he was slapped with two orders. First, an order of disqualification on section 28(3)(p), was disqualified to hold the office of chairman or in office bearer on the ground of having more than 2 children.
Oh, there is such a bar.
That is such a bar. If a person is having more than 2 children, then he is not qualified to hold the office of a chairman or representative, whatever the case may be.
Okay.
Now, subsequent thereto, the Committee of Management was placed under suspension 32(7) of the Odisha Cooperative Societies Act. Now, this disqualification order was challenged before the Honorable Single Bench. But the disqualification order has been passed by the Registered Cooperative Society based on an inquiry taken up by the Joint Register pursuant to an order passed by the state government. It is like this, madam. One MLA submitted a complaint for being nobody to the cooperative society. He just submitted an innocuous complaint to the government that, look, this person is not qualified. Government, on the basis of that complaint, passed an order, that's on record, directing the register to conduct an inquiry. Register constitutes a committee, and that committee conducts an inquiry. And on the basis of that inquiry, I was called upon to attend that inquiry. Instead of attending the inquiry, my client submitted a written reply to the inquiry. But my simple point is,
he participated in the inquiry.
No, not participated. He just submitted a written grievance.
It's a participation.
Participation. In this way only, he submitted a written note of submission, whatever he has. But that committee, your Lordship will find on record, has not considered that report. Neither the registrar nor the committee, none of them have considered that report. Report. I'm so sorry.
Yes,
Reply. And no opportunity of hearing was given to the petitioner because it's end in a civil consequence. Disqualification means you are killing the person from the office only. But no opportunity of hearing was given. The registrar passes a cryptic order directing disqualification. That's all.
Opportunity of hearing means opportunity of personal hearing. Oral hearing
or consideration, whatever it may be. Your Lordship will find, based on that report, which also do not consider my reply, the order has been passed.
What was the notice given to you? Let us see.
120.
Annexure 8 of the report.
Annexure 8 of the report, running page 120. This is the disqualification order.
How proceedings emanate?
Right. Now your Lordship may kindly see page 180.
How the genesis?
Yes, Lord. Page 180. See you government order ka lagai. Where is government office? Yes, Lord. Yes, Lord. Kindly see page 180, 16/8/24.
Annexure?
This is annexure C/3 of the counter. Running page 180.
WPC 29872.
Why so many matters here?
Beg pardon?
How many appeals are here?
There is a second appeal in which I am appearing. That was a challenge to the suspension of the committee. This was never heard. And by a common order, both the applications have been dismissed. This was never heard, it was not there on board.
Common order. But after dealing with disqualification, the Honorable Single Judge says that in view of dismissal of this, though the causes of action are completely different, and the orders are completely different, in view of dismissal, that suspension matter has been dismissed. That's all, without dealing with the matter at all.
I am appearing along with Mr. Kanungo in the next appeal. There in the case was...
There are 3 appeals.
There are 2 appeals.
Two appeals.
Yes.
One appeal where it is held disqualification.
The other appeal In fact,
suspension.
the order of suspension of the committee was challenged, and the suspension order of the committee in a different grounds. And while this was disposed of, it was said that since it has been disposed of, that is also disposed. You also look to the order.
In view of disposal, some of the read, the other it has been disposed of. Irrespective of fact
That has not been considered at all.
Not examined.
Yes.
Not examined at all. That is at running page
So,
26.
no, why then both the reads were taken together?
They were not taken
There was
together.
nothing analogous.
No, occasion that should have been detagged and that should have been.
They should have been heard separately.
The same
and
society.
This was never heard. The only hearing that took place was regarding the 2 children, 3 children portion, my lords. Whether he is entitled to continue or to be disqualified. Now, if your lordship sees 26, in view of the page 26 of my brief, in view of the common judgment passed in the writ application is dismissed. We have never been heard in this matter.
The proper course should be let it be given an opportunity of hearing so far as the disqualification is concerned. Then let them take a decision after giving an opportunity of being heard. Then these are all consequential. So far as the suspension is concerned, they must give an opportunity also.
Now, as your lordship rightly asked me, kindly see page 179.
179.
That is the emanation of the entire dispute. 20th of April 20.
179.
Annexure B by 3.
Annexure B by 3 of the counter. Running page. It's running page.
Then 179.
This is running page.
B3.
That order dated 20th of April 2023.
In inviting a reference.
Yes, right. So great. In inviting, this is the order passed by the government. This is how the entire issue started. In inviting a reference to the subject cited above, I am directed to enclose here with a copy of DO letter number so-and-so of Sri Jayanar Mr. Leader of Opposition Odisha Legislative Assembly Odisha, Bhubaneswar, as received from the Chief Secretary Odisha regarding illegal selection of a candidate for the post of Chairman Odisha Housing Corporation with the request to inquire into the matter and furnish detailed status report to this department at the earliest for taking further action at this end. But this was the government writes a letter to the register to inquiry. It's another issue. The scope of inquiry will take a lordship within the framework of Cooperative Societies Act. Such an inquiry is not permissible. I'll show you, lordship.
Whether that ground was urgent before the single judge?
But in fact, it's a pure. I don't think in the judgment it's not there. But then it's a pure question of law. That your lordship can kindly consider it. Kindly similar this letter.
Whether that contention is taken up in your appeal memo?
Yes. But page 180, your lordship may kindly see. That's the next page. Enclosed, please find here with allegation of so-and-so. This is order passed by the register. Jayanar and Mr. Leader of so-and-so, Bhubaneswar, received from the government, dated 20th of April 24, which is self-explanatory. You are requested to conduct inquiry. He writes to this committee. Now, this committee takes into consideration to certain FIR lodged against the petitioner. That FIR is at page 183.
Why?
By some other person.
No, for which offense?
This is for having more than 2 children.
For 420.
420.
Because he has deceived the authorities by suppressing this fact. This has been stated by this honorable.
This has been stated by this honorable.
This FIR.
But basis of the inquiry, this FIR. No punishment, no conviction. It is only pending. Based on this committee takes up.
Criminal proceeding is state.
Yes.
Yes, it is state.
But the other proceeding is not challenged. You are challenged.
Proceeding is challenged in this before the honorable single judge. Yes.
After you suffered the order.
Yes. Now, after this, the learned register passes this order. Now, the inquiry committee conducts an inquiry and submits the report.
Under the act, since I do not know much about your Cooperative Societies Act, although I know Karnataka Petition, Central Cooperative Societies Act, these things I know. How, if question as to incurring of disqualification, who should decide and how?
Lordships, I have raised a very, very pertinent question. So far as disqualification 28.3p of the Act, neither Act nor the rules, they do not provide any procedure to be followed, do not designate any officer to pass the order.
Then Cooperative Department can do that.
But then the supervisory power of the register. Supervisory power of the register is there over all the cooperative societies. So that power is there. That power is there. But so far as the inquiry is concerned, your lordship will find in the framework of Cooperative Societies Act, there are only two provisions for an inquiry. One is section 65, other is 123A. 123A, if your lordship will kindly see, where the government will pass a direction for an inquiry. Whether against a particular individual, there can be an order of inquiry by the government at all. In my humble opinion, answer is no. Kindly see 123A.
No, assuming that it does not fit into 123A, but there is a provision in the Act as a matter of policy.
Right.
That person having 100 children should not become.
No, that's there. That's there. That is absolutely
So
there.
that is there.
That is there.
If it is there, then some mechanism has to
be there. Has to be there.
Statute itself.
Has to be there. But apparently it's not there.
No, then we have to invent one.
Yes. So the power minister is
defeat the purpose of the
in that case, so the whole procedure followed gives a very wrong signal. Because 123A, if your lordship will see, 123A
No, it cannot fit into 123A.
Never fit in, because 123A says that consequent upon an inquiry, a person will be given opportunity to remove the deficiency.
No, that is, this cannot be removed.
This cannot be removed.
Already bought.
That cannot be removed.
Therefore, that section is not applicable.
Not applicable. Then section 65 equally
may not be applicable. But still there will be power.
Yes, ma'am. So if the
conscience keeper of the cooperative movement under the Act,
yes,
he will be holding.
So they are only, therefore, I have sufficient documentary evidence, materials to rebut these allegations against me. Sufficient. So I just...
No, two things. You have raised a point, which you said it's a pure question of law, therefore it can be entertained. That's how we have said. The power to hold inquiry.
Yes.
So you still stick to that
But I only stick, give me an opportunity, that's all. I'll go back to
So
the
you
register.
are on processual justice.
Yes. I'll go back to the register. He will give me an opportunity.
What opportunity? You already given the statement, reply.
No, that reply has not been considered by anyone.
That is another ground.
That is the only point.
That is a case of non-application.
That is the only point. Today I am
opportunity of hearing.
Non-consideration even, madam.
That's all.
Kindly see the disqualification of
if you are given liberty to make representation, that itself is a participation.
My representation was there. They have not considered it. Non-application.
Non-considered.
In MCL case, your lordship considered this part and passed an order giving them opportunity to go back and consider that case. I can rely on that.
Who is the first authority who decided this?
Right. But if the Registered Cooperative Society disqualification order, kindly see the order that is on page 170.
Any special power given to the register? Where is the powers of the register?
Yes. Kindly see. Disqualification order taken.
Powers of the register under the Act.
Blood special power is not there.
General powers.
General power. That's there. The register's power is here. There shall be a register, section 3. Section 3.
Yes.
Section 3. The state government may appoint a person to be the registered cooperative society of the state and may appoint other persons with prescribed designation to assist him. The state government may, by general special order, confer on any person appointed to assist the register all or any of the powers of the register so and so. The state government may also decide the appointment of the register. Now, register's power, register means a person appointed to perform functions of the registered cooperative society under this act and includes any person appointed to assist him.
Which are those functions?
Absolutely. One second.
So he has to perform the functions of the registrar of cooperative societies under this act.
Right.
Therefore, there must be certain functions. If a person cannot continue to hold a particular office on incurring particular disqualification,
right,
then he has to ensure that such person cannot hold the office.
Right.
So it falls within the general
power. That's
where are the powers of the registrar?
That is,
there must be some provision.
Section 28, Lordship will see the power of the committee. Then
no
register's power. I don't think any specific definition.
There must be some provision. This is a very old act, 62 act. Maybe Mr. Ratho was not born also.
But the 62 no, I was not born. Your Lordships are correct. Register's power, I don't think any defined power is there. Register. Then section 68 is there, my lord. The 67. my lord.
67.
67 is there.
The cooperative tribunal.
No, tribunal is not.
Registrar.
Registrar.
No, registrar.
68 should be 68. my lord.
Arbitration. It is.
No, this is the signal. Notwithstanding anything contained in any other law for the time being in force, any dispute causing constitution, management, business of a society, other than a dispute so and so, shall be referred to the register if the parties thereto are among the following persons. This is the power on section 16.
No specific provision which enlists functions of the registrar.
No specific power that I have examined. 28(3)(p), no specific power is there. Only this 68 power of the register. Inquiry by register. Let's see. That's what I was saying. Inquiry by the register is here. The register may at any time of his own motion by himself or by a person.
His own motion. That is suo moto also.
Suo moto.
He can do that.
He can do that. Suo moto, kindly similar to what extent he can do. What can he inquire into? Authorized by him by order in writing, hold an inquiry into constitution, working and financial condition of institution. That too again, by whom it can be initiated. Kindly see 2. An inquiry of a nature referred to on subsection 1 shall be held on application of.
No, that is second part.
That is second part.
First part is suo moto.
Suo moto is there. Suo moto is there. Yes. Suo moto is there.
Where it is not suo moto, then courts have held. It falls into this part.
It is on by the order passed by the government.
It's an information.
Someone has to set to motion.
He input given to the register.
Yes, because he is a mercenary. He is a mercenary.
Otherwise, suo moto.
He has been initiated. Yes. That has been interpreted by the full bench of this Hon'Ble Court.
There is such a judgment.
Yes. Suo moto, there is a full bench judgment of this Hon'Ble Court in Gram Panchayat Act.
So, if anybody argues that he has no power, perhaps he has an uphill task to convince us.
Beg pardon.
If any one of you argues that he has no power at all, having power is one thing. Exercising power is another.
Right, man.
Existence of power is one thing.
Right.
Its exercise is another.
Correct.
You are perhaps on the administrative law. Exercise of power.
Yes. Kindly see, my lord. Kindly see, then if it is under 65, then kindly see 4 also.
4. Where the inquiry is made under this section, the registrar shall communicate the report of the inquiry within 3 months from the date of commencement thereof to the society to its affiliated for its financing auditor to following its solution of such other.
So this is not relating to any disqualification. That's what I'm trying to tell you. This inquiry is something
working of a society.
Working of a society.
How courts have interpreted it? Judges of this court have
any judgment on that.
No, there are judgments. There are judgments. I saw last year when I came here, on the first day, some judgment was cited as to what is meaning by working constitution of the society. Myself and the brother K.R. Mahapatra sat. We heard one matter. So we did not conclude it. Is another thing. I remember.
Working of a society, if includes disqualification of the chairman, Lord, that subject to interpretation of the Lordship, my Lord. That's something which I should not venture to.
No. Just many law students will be here. Interns are here.
Definitely.
Tomorrow,
they will definitely learn out of it.
Are the members this side.
Right, but kindly see at page 120, that disqualification order itself. Kindly see, if your Lordship find that it is laconic, kindly see.
No, let us see, what is the notice given to you?
That notice I have given to you, shown to your lordship, Lord, page 179.
That notice.
Yes, now notice by the inquiry committee, not by the registrar. That's 179, no? Kindly see, brother. It was secretary order. Notice of participating in the inquiry. So notice to that. We give the reply to the report. That notice given to submit reply to the report. It also inquiry order. It a register order. Then where is that notice? Yes. No, it's a disqualification.
Section 65 is inquiry by the registrar. Whether he passes the order.
He passed the order.
There is no, under the scheme of section 65.
Right.
Whether he passes the order. What is that 65? Then he passed an order which is a proprio vigor enforceable. On its own enforceable.
65 doesn't show any order. He only passes an order as to inquiry. Then once the inquiry is held and something latches are found with regard to working or financial irregularity, then surcharge proceeding. So this is the thing I was hinting at. 65 is not unqualified. See, notice taken, people can look at it. Then you give your reply. I'm going to notice that. Permission.
Suppose once he is disqualified,
yes,
which is the forum where you can agitate your grievance under the act. Any expert in
provision under section 67P, a dispute can be raised before the tribunal. Here is a case which Mr. Roth can show also the part of the records.
But you are not in this matter.
I am in the collective matter.
You are not concerned with this case at all.
No, I'm saying
because that is also one part of our case.
No, you are not a person in this case. Yes, Mr.
Lord, that is there. If your lordship sees 113, section 113.
113.
113.
Mr. Kalandra is appearing for.
I'm appearing in the second matter.
Both you can take your seat. You need not disturb.
Both are appearing for second.
Yes, 113.
Yes, Lord.
Power of revision by state government. The state government may, of their own motion, or an application by any person wishing to accept the bail, or of a given party in terms of the reasonable objects have been heard, call for and examine the record of any proceeding before the registrar. Any proceeding under section 112 before the registrar, there is no appeal done for the purpose of settling itself as well. Again, the right of any decision made, orders passed, so there is a revisional power.
There is a revisional power, but my humble prayer before your lordship would be, if your lordship prima facie finds that there is violation of natural justice, if there is violation of non-consideration of materials and record, non-application of mind is also one of the facets of the natural justice. If your lordship finds that there is non-compliance of that, relegate me back to the stage, why to miss a forum? I am willing to go back to the register, let the register give me an opportunity and then finally kill me.
Now, when is your reply to the registrar which you had sent?
Not that. My reply is at page
Page 202.
Page 202. Page 202. Annexure E by 3.
After the registrar passed the order, you went before whom?
We challenged that before this honorable in this before the honorable
single judge. Yes, Mr. Ratho, you wanted us to look
Page 202, my lord. I was trying to show your lordship the disqualification order passed by the registrar himself. If your lordship permits, I can show that, or I'll straightway go to the.
No, let us see that order.
Your lordship wanted
we wanted to know where is your stand.
Yes, page 202, my lord.
Go to 202.
Of their counter. Page internal page.
Annexure E by 3.
Annexure E by 3. E by 3 of their counter. This is the reply he has given to the joint register.
It's not. No, it is not. Do you have a copy of that?
Yes, ma'am.
Yes, sir. You have not made it part of the record.
It is there part of the counter. It's there. States count.
Whether two persons or not, it is. He says it is sub judice in
the High Court.
What is that?
That the FIR forming basis of my disqualification. That proceeding.
That is a criminal proceeding.
That proceeding itself is challenged before this honorable court, and that has been stayed. For further proceeding has been stayed. That's all. That is the all. That's all. On it. FIR is the basis for my disqualification. A charge sheet has been filed. I have been disqualified.
No, where you say you don't, you have not begotten 3 children. Where is that sentence?
That's not there. But in my IA, I have given documents in some.
That makes no sense.
Blood in the blood. That's not very happily. That's not very happily drafted. That's not very happily drafted. Before the honorable single judge, we have produced all the matters.
That's the crux of the case.
You should have said, I do not have 3 children. Here I have only 2 children, or that I have 4 children.
Blood in the.
But that also would have helped because
I humbly concede. I humbly concede. I humbly concede.
Denied it.
I humbly concede that it's not very properly drafted.
No, it is not only proper.
No, it's absolutely wrong. But can I humbly pray and request, my lords, that I have filed one.
Rather, it is honestly drafted, my lord. It is honestly drafted, but he has admitted the fact.
Not admitted. Kindly see my IA.
Sometimes truth trickles out.
Kindly see my IA. I have given in sufficient number of documents.
What for?
Blood, I have given that.
We understand. Document is evidentiary in character. Evidence is in support of a particular stand.
Yes.
Where is your stand that you don't have 3 children?
Blood, those stands are before your lordship. Blood in the shape of IA with affidavit I have filed.
They were not before the single judge.
Blood,
IA before whom?
Blood, that inquiry committee.
No, IA before whom?
IA before your lordship.
What I should do with that?
Blood,
we are not the deciding authority.
Blood, your lordships are not deciding.
Authority has decided.
Yes.
It gave a copy to you. This is how the leader of the opposition has said to the government. Government has said, if you want to say something, you say that. You have said.
Right.
Not even whisper is made. You having not forgotten.
Yes, with folded hand.
No, not necessary.
Yes, Lord. Lordship, kindly see that report at least, Lord.
Yeah.
Kindly see that report. That report, the FIR forming basis of that report, that's all. can one FIR can form basis of my disqualification?
We are not on the FIR is being examined by somebody.
So that is what.
No, where have you denied that you have 3 children?
But I have denied everywhere.
On the same day, they should have
before the Hon'Ble Singleton, I have denied. But there are additional documents which I can.
It is not a single judge who takes the decision. Decision has to be taken by the registrar. Registrar sent you to the notice. In the notice, you did not say, "Sir, I do not have 3 children. Where from they have got another child, I don't know. In fact, we have only 2 children."
Lord, that is apparently, my lord, it's not there in the reply. But I humbly pray, my lord, I can persuade my lords. Kindly see the documents which I am filing before the Hon'Ble Singleton and your lordship.
No, who are we?
Lord, therefore I am praying, my lord. Give me a chance, I will file these things. Therefore, I am praying before my lords, my lord. I am not father of 3 children, my lord.
We have great respect for your acumen, etc. That is another thing.
Kindly consider, my lord. Kindly consider. I am not father of 3 children.
Where have you stated?
But in the reply to the inquiry report, it's not there. But there are documents to demonstrate.
What we should do with the document? You got evidence. Provided you take a stand, if you take a stand,
right,
the evidence becomes supportive.
Well, I can see, but that report, my lords may kindly see. That report, at least my lords may kindly see that whether that can form basis or not. But at least whatever I have said in my reply, that should have been considered at least, my lord.
What they should
consider? I have said whatever I have replied, I have given.
Whatever you have not, you have left unsaid. That also should be considered.
But I can't. I certainly cannot win over. I certainly cannot win over my lord's opinion. I certainly cannot. But with what I
said, what English judges have said is non-application of mind to what is said or what is there on record.
Yes.
If you do not take up a stand,
yes,
that I do not have 3 children. God has given me.
Lord, what I am saying, kindly see, Lord. What I am saying.
Let us
kindly see, Lord. There are multiple allegations here. Lord, what I am saying is, Lord, in my reply, written submission I am giving, kindly see, Lord. The allegation concerning the violation of Section 28(3)(p) of OCS Act 1962 regarding having more than 2 children is currently sub judice in the High Court of Orissa. It's a matter of legal determination until a final verdict is delivered. It cannot be used to prejudice my position or duty within the cooperative society. This I am saying, my lord. But yes, I cannot improve upon this. But at least I say that I have challenged this FIR where the allegation of 3 children is there against me before this honorable court.
Not allegation. Initiation of criminal proceedings against.
Not in the FIR allegation is that I have filed
bribery, corruption, all other things are there in the FIR.
Not kindly see the FIR.
Fraud is also there. I saw that.
Lordship has seen that FIR.
Yeah, I saw when you were turning the pages.
But it is in Varna. Kindly see, Lord. Kindly see, Lord.
Yeah, go to it.
It is only 3rd children. It is only pertaining to 3rd child. Kindly see, my lord. It is in vernacular page 27. My lord, all just that. Yes, ma'am. Kindly see this FIR. This is only pertaining to 3rd child. Kindly see, ma'am. And I am challenging this FIR before this honorable court in that Sierra Leone.
I read the fraud, bribery, corruption.
No, not there in the FIR. In the FIR, it's not there. They are saying something beyond the purview of the FIR. Merely on the basis of FIR, they are disqualifying me or charge sheet. Whatever is the case may be, my lord. Kindly see the FIR. Lord, I am reading it. सूचित करे कि मु कैपिटल कोऑपरेटिव निर्देश थिया समय रे 26/5/20 मिलट पेज 183 मिलट पेज 27 of their counter. Kindly see, man. Only to the third child, this affair, no corruption allegation. And this has been under challenge before this honorable court.
Because having 3rd child is not an offense. Rightly your challenge.
That is what the case.
No, rightly your challenge. But it is not that you do not have 3rd child. Your case is no offense is committed. If my wife beget 3rd child, what is the offense here?
Not 420, allegation of 420 and other things are there.
They are there.
That is the reason in my case, Sierra Leone, I am disputing this now. And I have taken this plea. Look, I am challenging the affair before the honorable.
Any other ground? No, we will consider that. We will consider. We understand.
Lord, all that today I can print for my lord says, my lord. Give me an opportunity. I can. But these documents.
How are you removing the third child?
Yes. Lord, ask the right question, but kindly see. Lord. Every document, Lord, kindly see. Lord, there is an award passed by the cooperative tribunal in connection with my wife. My wife, that's she has not begotten a third child. The cooperative tribunal gives a judgment on the same allegation on the same child, gives a judgment that she has not begotten a third child. That is one.
When it was given?
Beg pardon?
When it was given?
Well, it was given in 2015.
Then afterwards, where is the finding that after 2015 I have not begotten any child?
But kindly see the child date of birth is prior to 2015. That's their allegation. This third child is prior to 2015, and this third child has been adjudicated in 2015. That I do not have, my wife do not have a third child.
How that question arose before the tribunal, before the...
No, the election dispute was raised. She was a director of the, before the cooperative society. An election dispute was raised by one of the directors that this very disputed child, pertaining to this very disputed child.
You were not the party.
My wife was the...
Then how can you take up?
No, my wife and me.
These are not the judgments in rem.
Right, my lord.
But whether one is your wife, a person's wife or not, is a judgment in them.
Yes.
Once it is held, she is wife.
Yes.
She is wife or world at large. That
yes.
Is. But whether one has begotten 3 children or not,
yes,
that is not a judgment in them. It's only judgment in
not at all. Not at all, my lord.
If that is so, then what is the value of...
But that very disputed child was subject matter of consideration here also. But it's not binding to the present complainant. That's right, Milord. But then your lordship will see the equity part. That very disputed child was the subject matter of consideration here. And it was held that my wife has not begotten that disputed child. That is one. 2. Kindly see the certificate issued by CBSE, Milord. In respect of that disputed child, my brother is his father. That disputed child's father. Kindly see page 19. Susmita, it is like this. My sister-in-law and my wife's name are tallying. That is the whole confusion they are trying to raise. The CBSE issued a certificate of that very child, Vibhudananda Mahanti, kindly similar, is son of Biswajit Mahanti. And Susmita Mahanti is the mother of that disputed child. Name of my wife and Susmita Mahanti are same. Kindly see page 19, Lord, this is CBSE certificate. Then kindly see, my lord, this is...
In criminal petition also you have taken up the contention that you don't have 3 children.
Yes, my lord. Yes, my lord. Then kindly see Aadhaar card, my lord. Aadhaar card of, is a passport, my lord. Kindly see passport of the disputed child. My lord, Biswajit Mahanti is the father and Susmita Mahanti is the mother.
When the passport is obtained?
Passport is
Date of issue.
Date of issue is 21/7/2025.
So when the issue arose before
that, the issue has been raised.
Thereafter you obtained it.
Yes. No, but these are certificate, the CBSE.
You have obtained it after
the correction. The certificate is on the basis of the entries much prior to the issuance of certificate.
No,
before the CBSE.
This, since you are banking upon this,
right?
This is a document post latest.
But certificate is post. But entries in the register has to be much prior to issuance of certificate. Kindly consider, madam. This certificate is based on entry in the register available in the school. And that school entry was prior to, from the date of admission, much prior to the dispute arose, madam. Kindly consider this. Certificate is 2025. Am I?
Yes.
But one more, Lord. Aadhaar is also the same thing, my lord.
Aadhaar is obtained in which year?
Well, they are all post. Lord, I have not generated this, but CBSE certificate I cannot. The entry in the register I cannot. School admission register is much prior to the dispute arose. They have issued the certificate in 25 basing upon the entry in the register. And there is nothing on record. Of course, Lord, they are subject to again verification, madam.
You have not made one single sentence in your representation.
But in the criminal mistakes,
I do not have 3 children at all.
But I not
sentence would have been.
But everything being aside, Lord, everything passing aside. Lord, kindly see the discharge certificate of the child. Kindly see, Lord, discharge certificate of the child, my lord.
Discharge from the hospital.
From the hospital.
When it was?
Lord, it is 2007. Birth. Discharge summary. Discharge certificate, kindly see, my lord, the hospital has given it.
Discharging after.
No, that is after correction.
The report of the.
Originally, the petitioner's name was there. Thereafter, he applied for correction, and after correction, this new document.
No, that is the certificate he is asking, not the discharge certificate. Discharge certificate. Yes, no, birth certificate is based on correction, but discharge is there original.
In the birth certificate, name is shown as father.
This is not based on correction, kindly see.
No, we are asking a question.
I'm sorry.
In the birth certificate, whose name is shown as the father?
Birth
certificate, just a minute.
No, birth certificate.
Filed that.
I am arguing, I don't know for whom.
1 minute, but I'm asking for intervener or just to point out my.
I'm replying. 1 second, Mr.
Just a minute.
I know, let me answer. If I succeed on the basis of my submission, it's okay. No, please.
You need to bring the certificate relied upon by the government officials. They have
kindly see. I know what are you trying to tell. Kindly see, page 24, birth certificate. Birth certificate, yes, Biswajit Mahanti is father, Sasmita Mahanti is the mother.
Your client?
No, not my client, my brother. Biswajit Mahanti is my brother. And discharge summary, at least I have not corrected, my lord. It's available in the hospital.
Discharge summary is prepared on the basis of somebody who took the patient to the hospital. Some doctor writes it. Correct. Some doctor will write it. There are such judgments under motor vehicle act. Therefore, we are telling you.
Lordship will take all these, all these things, my lord. I should have been at least given an opportunity. That's all.
What opportunity? Given in writing.
I'll bring this.
The father is Biswajit Mohanty.
Yes, my brother.
When this
2007.
This original certificate was given when?
2007. The date of birth is 23/6/2007 and the origin
2007.
And the original contains the petitioner's name.
No.
My lord, thereafter he has applied for correction.
Therefore we are asking.
My lord,
what fault
that original? Give us.
Let them produce the original.
But that is there, my lord, in annexure.
Annexure.
Annexure H/3.
Subsequently, he got it rectified. Let the order of the magistrate under section 30.
No, let them produce the original.
That was issued, my lord, that last test was, as per that record, but it was issued on 31/1/2023.
Which one?
The certificate, my lord, the government relied upon that day birth certificate. That is at annexure G/3.
Yes, to go to G/3.
G/3 to the countered by filed by the government in WPC number 29872 of
2023. Father's name is what?
Father's name is Chinttaranjan Mahanti.
That is the appellant here.
Yes, my lord. Yes, my lord.
G3.
Then thereafter, my lord, the important part is thereafter. Clarification. Detail.
Maybe that's the reason they have filed the criminal case against him.
The next one, my lord, the register birth and death. Health officer.
Child was born in the hospital or at
hospital?
Hospital. Who reported?
Should I bring those records before?
This is 227.
Right.
I'm coming in appeal. That's all.
Yes.
So I'm only reading 2 lines in respect of annexure H/3.
1 second.
G and H/3.
Again, he applied for correction on 24.
H/3 would clinch the issue. This document, he is seeking for correction post this dispute began.
Correction.
So what falls from your lordship that all these documents are now being tried to be created after this list has begun.
Lord, kindly see. Correction of the certificate, but entries are there which are original. Lord, can I request your lordship? I'll get those at least originals and produce before my lord.
Heard. Original. What you want to say?
We want to say that bypassing the revisional forum, they have approached the Honorable Court, which should not have been, the writ petition was not maintainable ab initio. They should have approached the state government under the power.
Did you take up that contention before the single judge?
Yes, yes. Yes.
You have taken up that contention?
Revisional, yes, that is reflected in the order itself, impugned order. London single judge has dealt with exhaustively the contention of both sides. Well, it is a well-speaking order and an indefeasible order in my humble submission that every part has been taken care of, and they are saying that the other petition was not taken off. Other petition was tagged and it is reflected in the cost title that both the petition are taken simultaneously in the paragraph 1. There is an explanation to that, my lord. Issues are same.
The reasoning.
Reasoning is in paragraph 9. Paragraph 9. Yes, paragraph 9 onwards. Paragraph 9 onwards.
How suspension can be consequential, brother?
Suspension.
This whether one has got 3 children, 10 children,
suspension.
That is one thing. Assuming that he has got 11 children. Gandhari had how many children? 101.
The statutory embargo, my lord, statutory embargo, it has come to the knowledge.
That will come to suspension of the managing committee.
No, that is on the conjoint order, my lord.
That's also
That's a conjoint order.
That suspension order, my lord, itself not only refers to three
first case,
refers to irregularity, financial irregularity.
Yes. That is the jurisdiction has been invoked.
What they will.
Can you also look to section 109? The appeal and revision. Why I am saying so? Because there is some. I'll make.
It is in relation to your case.
Yes, my case, the second case. Both Mr. Kanunga and myself are. Also look to 109. 109, chapter 13, appeal, revision and review, section 109. This order has been passed by the registrar.
That suspension order?
The order of suspension has been passed by the registrar. Please, I'm taking permission from the court.
This is appeal already. No,
first matter you are appealing.
I have appealed for the intervention. So that caveat.
In the first matter. Do you have anything to say?
Well, exactly. Already managed to point out that nothing more to say by us.
No,
because my restraint allowing the second case. Please. Sir,
109.
109, if you also competent. An appeal shall lie under this section against the following order and decision namely. You also come to F. An order of the register disqualifying or removing an office bearer or a committee of a society under section 32. So this order is applicable. Sir.
Removing the committee of society.
Sir.
Where is the removal?
Sir, this order of suspension, you also look to 32. That says an order of the register disqualifying or removing an office bearer.
Correct.
Or a committee of society under section 32.
Or a committee of society, which is the prefix for that.
Right. So section 32, now the power has been exercised when passing the impugned order annexure 2 at page 26 in the second matter, at page 87. Page 87. Just one. Subject to your lordship's acceptance, why I am saying so. Because by the time you lordship asked the question that why you have then approached this honorable court in single judge. In fact, there was no tribunal. There was no tribunal functioning at that time. And that is one of the findings of the honorable single judge also. That is para 9 is accepted.
Therefore, he exercised that.
Sir.
Then on the merits, what is?
So far the merit of the case is concerned, your lordship rightly put that question. So far the disqualification is one of the ground maybe, but there are other grounds also. So far the committee is concerned. You can place a committee under suspension. Vishwaranjan may be one of the members, that's a different question, the president, but you have placed the suspension under exercise committee. Sir. So we have a right to go in appeal.
If one member, see, this is a disqualification for becoming, holding office of the chairman, not for membership.
Sure.
Mr. Rato, whether Your disqualification is for holding the office of a chairman or for membership also.
The entire thing will be, one second.
Let us see the section.
Wait a minute. 32, no, disqualification. This is
It's for the office.
No individual, sir, whether by himself or as a representative of the society, be eligible to be chosen or for continuing as a member, president, everything.
Okay. The wholesale disqualification.
Before my letter, may I just put a small request to my.
Yes.
The disqualification is lifetime. Once today I am disqualified, for the entire lifetime I cannot come as a member even go ahead. So today, before killing me, my lord, may I just pray? Allow me one opportunity. I'll.
We have heard. We will not give to so much. Mr.
No, my lord, I'll go back to them only, my lord. I'll file a revision, my lord. I'll
argued on merits. Now we will decide it on merits. Yes, sir.
Sir. So far as the section 32, if you also look to that page 87.
Which is the power to suspend
32. 7. 32.7. And the power of the appeal is to be preferred against the order of the registrar against an order on section 32. 32 include 32.7 also.
Suspension of committee with power to disqualify officers of the society if in the main operations being committee of consistently body allegiance. Stalemate is constitution. On which ground?
Sir, can you also look to page 87? There is no allegation against the committee. You also look to that. Just one. Sir, the third paragraph. Whereas Orissa Cooperative Society compares of Bhubaneswar being a premier cooperative society institution of the state is supposed to manage the affairs.
Committee is a legal entity, legal person or only like a association?
Association.
Like association.
Consisting of people.
So, if one or two members have done something,
the whole committee cannot be.
Why? Your committee is more like a partnership firm. Therefore, I asked you whether it is a legal person or it is only a name, collective name for the committee. Committee is collective name.
That the committee as a
is it defined? See that committee is defined. If committee is a legal person, unlike a partnership firm.
No, not a
partnership firm is not a legal person. Partnership firm is a collective name for the partners. Section 4 of the Partnership Act, etc.
What I'm trying to
definition of committee is under 2C.
Yes.
Committee means the managing committee of a society by whatever name called to which the management of the affairs of the society is entrusted by or under this act or by the bylaws of the society.
Therefore, it has no personality, corporate personality is not there. Unlike a cooperative society, it is a corporate entity because it survives even if all the members of the society are bombed to death. Like Solomon versus Solomon and Company Limited. If all shareholders die, company will still survive. Similarly, in the society. But for committee, it is not true. Why this question is important? See, if some of the members of the committee do something, then committee can be suspended for that reason. But it is not that committee as such sitting in the full meeting should do some bribery, some corruption. Some of the members of the committee.
But that's not the case here.
No, they have just clarity.
Right.
For jurisprudential clarity, we are tweaking.
Yes.
Yeah. What is the ground on which you have been suspended?
You'll also look to based on page 87.
87?
Yes. Annexure, which was included before the
annexure?
The annexure at page 87.
WPC 18920.
Page 7. Page Page 26 of the writ application. Annexure 2. Yes. Page 40. Yes. Page 40.
What is the ground on which?
Because the fact come to first, second, third. Whereas the Committee of Management of Odisha Cooperative Housing Corporation Limited is allegedly committing irregularity of its illegality and not acting in the interest of the corporation and its members, working on the financial harassment to members, including inaction of the committee, leading in non-handing over the houses of the members in so project, unless management in the committee meeting, illegal sale of land and cooperation amongst members of the committee. Whereas as per section 2H1 of the Odisha Cooperative Society Act, chairmen are responsible amongst the members of the committee for the overall development and progress of the society and its members, etc. As per communication dated 23/7/2024 of ASI Lakshmishagar Bhubaneswar in Lakshmishagar PS case number so dated 10/10/2022 under section 420 IPC, the chairman is having 3 children and submitted the false information already the statute mounting.
So that's relieved. That makes no difference because it's a separate case.
And whereas in view of that is the basic. Whereas in view of the above, in my opinion, the Committee of Management of the Corporation acting in the manner.
What was your reply?
May I just assist your lordship in this reply? I think my landed too serious should consider this as good as your lordships also. C-32(7), a lifetime of a suspension order for a cooperative society doing its banking business is 1 year, other than banking 6 months. So 24/7/2025 was the order. And 6 months after, the suspension period also lapses by flux of time.
And you also writing
Means what?
Means the suspension, which was subject matter of challenge for the Honorable Single Judge, do not anymore survive. Unless a removal order is passed under section 32(1).
That already I'm going just now.
Legal effect is like that.
Yes. Kindly see 32(7) read with 1.
It has become infructuous for all purposes.
No, not infructuous. It has lost its force by flux of time. Yes. Suspension is no
Obviously, further remains to be decided.
Your lordship,
unless you remove
That's
the
combination. What to says sounds logical.
We agree with him.
Tenure of suspension is 6 months.
Yes.
After 6 months, suspension goes and it is restored.
Yes. Functioning. Yes.
Mr.
Function.
Whereas the second
Also, minor state, it probably continuing.
Unless
there has become only academic.
No question.
Right.
If while computing the 6 months, the order of stay should be.
I don't think there
There is no order of stay.
No stay.
There is no order of stay.
No order of stay. No.
How is functioning that? You have an order of stay now.
No. Suspension
order has not.
Suspension order has not.
Election has been.
Election has been stayed.
And they have not acted. So
32(7) read with 1.
Every time, whenever you come to court, you bring some new point. Every time. It's a good thing. We learn so many things.
And I was just sitting and listening to my landed senior submission.
I was the next commissioner of mine was there. It has already expired. And you have asked us, you have never asked us also to give a so called.
Understanding anything contained in this section. The opinion of the committee because the people or if it is not exceeding 1 year, in case of society, this is a non-banking society. Non-bank. This was the period not exceeding.
Mandatory.
So automatically by lapse of time suspension goes. So
It is restored.
restored. And the period of suspension is added to the tenure of the elected.
Yes.
That is there
That because of the proviso.
because of the profitable.
And then nothing remains in this.
Yes.
That judicial recording has to be there only, that's all.
My lord,
My case, may I be allowed to withdraw my appeal, man? Because I have read my lord's mind. I think I am not going.
Heard how.
But I can, Lord, here for lifetime you will go, Lord, I'll just withdraw my appeal. Lord, kindly consider it, Lord. Otherwise,
Withdraw appeal with no liberty to agitate the issue anywhere.
that, Lord,
Otherwise, you want to circumvent the judicial, but that will not allow. If you will agree for the finality, well and good, you can withdraw. Otherwise, we are holding that you have, no, if we hold that way, we don't know if you succeed also. We have only heard you. If your lawyer sense says that we are going to pass particular order.
Lord, unless a liberty is given to me to
No liberty. No liberty. It is already done. No liberty.
In that case, Lord, I should.
What we can do is, whatever we are observing here will not preclude you from taking stand contrary to that in the criminal case. That we can make observation. Otherwise, you may be prejudiced there also.
I'll be punished there also.
Therefore, what we suggest is, you withdraw, since you said.
That's right, Lord, that's right.
You withdraw the appeal with the caveat that the findings herein shall not operate for prosecuting your defense in the criminal matter. Otherwise, your claim may be put to prejudice.
That I am in, Lord, can I be given 1 day time to take instruction? Can we let it come tomorrow?
We are not passing order today.
Tomorrow.
We have reserved it. If we reserve, but it can move. If we reserve, it can move. Saying,
Lord, I only request, let me consult the tomorrow. Can we?
Our nature is like this.
I know.
I'm a court judge. I do not know. I am a court judge.
Mr. Das, sitting your lordship has already acquired your lordship quality, man.
This side or that side. We have heard.
I know, Lord, only for this, Lord. Only for
you want to withdraw. We will protect you. Saying, whatever is observed in the learned single judge's order or in the order of the authority committee, that will not prejudice your defense in the criminal. That favor we may do.
Yes. I'll make a statement tomorrow.
But we have not.
No, your lordship may reserve it.
No, your lordship will pass deliver a judgment if your lordship is reserving, my lord. You
no, tomorrow I
deliver a judgment on merit.
First order.
No. Then only thing
tomorrow
my learned senior, just Mr. Rautray had stated that it is appellable. My humble submission is not appellable, it is revisable. Under 1113.
That question now. After 6 months it is revived.
No, that is not the first case. First case.
In
the first case.
Makes no difference. Otherwise also learned single judge has decided on merits. Therefore, all your contentions will pale into insult.
No. And another contention is that in the so-called reply, he has not exhaustively taken all these grounds. So this cannot be taken agitated here before your lordship.
That is not going to.
That is our
take a judgment. Why unnecessarily spending time?
There is no.
What is the corrected manner?
Yes, sir. My lord, just to assist Mr. Martha,
you have to share your fee with us.
Yes, fellows. He is my son-in-law. Actually, in fact, he's married to a niece of mine.
But Mr. Rautray, your comment that I have acquired the qualities of my Justice Dixit.
Yes.
Is complimentary.
No.
But
not actual.
As such, my qualities
not actual.
Not that it is not beneficial to the bar.
Who says that? We have been watching. One case might go against us. One case that's very immaterial for us. hundreds of cases we are doing. But your lordship's contribution, I think we discussed in the bar in our lounge also.
All my brothers are doing. What is my contribution?
Well,
I'm expecting.
Well, it's just to assist Mr. Ratham. Well, your lordships are not passing the judgment tomorrow, my
Right now we are passing the order.
All right now. Because, my lords, in the criminal division, we had taken a specific stand and that was filed
In which case you are arguing?
My lords, in the first one,
You are not the lawyer.
I'm not the lawyer. I'm just
Then why do you take trouble? Yes. In a second matter. This intra-court appeal seeks to lay a challenge to a selected single judge's order dated whereby WPC number 18920 of 2024 current reason has been negative. But next correct. It is unanimously stated at the bar, which really is appreciable, that the suspension of managing committee of a cooperative society has a fixed statutory tenure of 6 months of a non-banking cooperative society. Has a statutorily fixed tenure of 6 months reckoned from the date of suspension. And therefore, the society, the committee, and therefore, the suspension withers away in minute by operation of law after the expiry of the said 6 months. And as a consequence, the functionality of the committee is revived for all practical purposes. First, next one. In view of the above, regardless of the arguable infirmities in the impugned order, we are of the considered view that matter has become infructuous. First one, this statement would not be doing justice to the party unless we make it clear that the managing committee in question is revived and that its tenure shall be, when computing its tenure, the period of suspension shall be discounted. No, I did. And as a consequence, with the above observations, this writ appeal is disposed of.
My lord, the authorities may not be precluded to take further action if any materials are there.
Order in our opinion.
If we do that, we'll be prompting them to take some action. Now, if you do it, then whatever you do it, but we don't. We will not say whether it is open to you or not open to you. Wherever it is. Thank you, Mr. Ratho, for assisting the court, saving lot of time of the court. Yes. Contempt will be contempt now it goes.
Yes, please.
It is in relation to suspension.
No, contempt is
Supreme order was there. Let's make drop it, without dealing with the matter.
It is anonymously submitted at the bar that the contempt proceedings would fade into insignificance in view of our order this day passed in writ appeal number 72. It's ordered according to the proceeding order. Next one.
May I, Lordship?
Yes.
I am appearing in person. Last occasion, delay was condoned, and I have challenged the judgment passing WPC number 2278 by 24 under Annex 2,
page 16 and 18 in this writ appeal. My lord, I am prepared some written note and some judgment in favor of me. One of is your judgment and another is the apex court judgment, and same judge grant relief other person, whereas myself negative.
No, that is not the point. Your Lordship may kindly see the impugn order paragraph 6. Paragraph 6, the reason has been supplied by the Honorable Single Judge, and it is not appealable at all, my lord. It's clear there is no appealability to challenge this order, my lord. 6 and 6.1. Clear arithmetic is there.
The new facts are there. Brought
6.1.
The last selected candidate is 95.434.
Yes, my
and
lord.
yours is 50.4252.
Okay,
Then how will you pay?
My lord, my submission is that there is some other category, they secured less than zero.
Less
than zero. I am everything right in my petition, my written note. And some judgment which was my favor. One is yours, my lord, and one is apex court. That if you permit, then I am submit. I am bring, and these facts are not in main rate appeal. It is new fact. Rate application, it is new fact coming after pendency this rate appeal.
After the disposal.
After the disposal.
Then you amend the petition.
I is there, my lord.
I for amendment.
I for amendment.
Which is that amendment?
No, I amend. If you allow, then I am correction.
No, where is that IA?
IA number is there, my lord. I am not IA number. I am telling you.
But this doesn't show any.
IA number 2132 is there.
Where have you pleaded new fact? You only sought for deletion and renumbering of the paragraph.
After disposal, the WPC, my lord.
Correct.
The same single judge decision is there in other similar cases.
You said that there is some new fact which has come up while this writ appeal is pending. Where have you brought this in amendment?
By an application, you have to state these are the new facts. These have come to light after the disposal of the writ petition during the pendency of the appeal. Therefore, give us permission to amend the appeal before.
Which are those new facts? Where have you mentioned?
I am not mentioned, my lord.
That you have to separately state. You should serve a copy on the other side.
Okay,
So that they will be able to meet it.
My lord, give me time, I will finally amend.
Call last week of July.
Because these amendments are formal. These are not important.
A copy of the IA should be served on us.
That's all.
Once the file comes.
I'm sorry.
To enable the appellant to file amendment application. Serving copy thereof. The other side. Well,
May I please your lordships? I may be pardoned, I am on VC, my lord.
no problem.
My lords, I have some personal difficulties. I have not prepared the matter. My lords,
Have it after 2 weeks.
my lord.
Yes, some personal difficulty.
Lordship, I am the owner of the house and I am ousted illegally by the e-auction process. And that has also been quashed by the appellate authority. And that is under challenge here in this Hon'Ble. And I am 81 years old and having the last stage of my life. I am suffering from the 4th stage of cancer. So my humble submission is let the matter may be posted on Monday.
How many matters are posted? Tuesday. Okay, Wednesday. United. 3, 14th of Wednesday.
Wednesday.
Because his client is suffering from 4th stage of cancer.
My lord.
On Wednesday, final two, at the request of.
My lords, interim order may kindly be continued.
You till Wednesday. Yeah.
22, contain 4/7/17 of 2025.
May I plead the lordship? This is non-compliance of order dated 31st July 2024, my lord.
Service is done?
No, my lord. They have
to go.
No, notice gone, my lord. They have filed one compliance affidavit, my lord. But in true sense, it is not compliant, you lord.
What was the compliance required?
Compliance was required as per order of the Honorable Court, my lord. My representation has had to be disposed of by the video.
Video?
My lord. Since 50 years, my lord, the petitioner's land has been enclosed by the opposite party by constructing a panchayat office therein. They did not, yes, my lord, my land. They did not pay a single pie. They did not initiate any land acquisition proceeding.
Lordship, that is our compliance affidavit, page 5.
Yes.
Direction was to consider the.
Yes, we have considered and we have passed favorable order in its favor, my lord.
Favorable order, but
yes.
Favorable order, but
Lordship, page 5.
Will you want to process the contempt?
Please 5, page 5.
In your favor.
But they are not paying any.
That is, direction is not for payment.
Exactly,
Direction is for passing order on your representation. They have passed in your favor.
In favor, correct.
And they have held that the Gram Panchayat has encroached. Yes, yes. Para 5, yes. They admit.
And compensation
Para
will be
7.
recommended. It is in process, you will get all compensation.
Yes,
In what period will you get?
That is the other authority, some other, that is District Compensation Advisory Committee has been directed to pay, and there also the orders, my lord, that they are in calculation.
How long they will calculate? It's not
no.
Some nebular process to go for a theoretical mathematics. Simple. How many acres of land enclosed? What is the compensation payable?
BDO, he is proceeding against the BDO. Now it is before the collector.
Only because first writ petition was filed wherein my collector was directed. Collector, after collector was directed to do something, my lord. Thereafter, collector referred the matter to the BDO, my lord. Again, my representation kept pending before the BDO. Again, I can.
BDO has disposed of
petitioner is 84 years.
You tell when you are going to give the compensation.
Let him arrange the collector as party, my lord. Then I will ask the collector to come with a compliance affidavit. Because collector is not a party here. BDO has referred the matter after adjudication.
BDO.
No, there is a direction for payment of compensation.
No, that is not that. No direction.
We have said in the
BDO has recommended for compensation. Yes.
You have done with that.
Yes. That I have to seek because collector is not a party here. Collectorate is not a party here. Only BDO.
Okay.
It's a technicality, my lord. Therefore.
Now the BDO was.
We are duty bound to pay. Your lordship may direct that, observing all this, that the direction maybe also can, your lordship, 226 or contempt, your lordship can direct.
No, he is not a party.
He is not a party. That's why I am saying so.
Or either parties are not properly implemented.
He sought for a direction to the BDO. Direction was given to the BDO for
in earlier writ petition, collector was directed.
Earlier writ petition.
Earlier.
Now the contempt is next writ petition order.
In the next last writ petition, my lord, WPC 17971, the BDO was directed to do something. That is why I made the BDO.
He has considered and recommended to another person who was not a party to the proceeding.
I will make them party, my lord.
Where?
Tomorrow?
No, where is this matter?
Yes, man.
How can he be? He was never a party to the original.
In the earlier requisition, he was a party man.
Makes no sense. Anyway, some observation we are making.
Yes, yes, my lord.
The complaint alleges non-compliance of the order dated 31/7/2024 entered in complainant's WPC number 17971 of 2024. First, after service of notice, the contemners having entered appearance through the learned EGA have filed a compliance affidavit dated
Complaints affidavit dated 3/2/2026.
3/2/2026. 3/2/2026. Affixing
order dated 31/1/2026.
copy of order dated 31/1/2026 as an Exhibit A,
My lord.
which reads as a next one. Learned counsel for the complainant submits that though in terms of compliance affidavit and the documents accompanying the same, the encroachment is admitted and a recommendation is made by the contemner for payment of compensation in respect of the encroached area, that exercise has not been undertaken.
I have no instruction, Your Lordship.
He's saying
Yes.
undertaken. First one. Therefore, to give effect to the orders of the court, further orders be made. First. Next one. At this stage, Mr. Panda, learned EGA, appearing for the contemner, submits that the decision has to be taken for the payment of compensation on the basis of the BDO's recommendation by some other authority who is not a party eo nomine to these proceedings, and therefore he is helpless. There need not be a plea of helplessness in matters like this. Next one. In matters like this, in as much as courts do exist for doing justice and not for passing some orders for the purpose of photo framing them. First, the authorities have to do all endeavors for giving effect to the letter and the spirit of the orders of the court. First, with the above observations, authorities that should be has to do all endeavors for exercise. Next one. In the above circumstances, these proceedings are dropped with a direction to the concerned authorities to
District Compensation Advisory Committee.
District Compensation Advisory Committee.
Under the chairmanship of Collector Kandhamal. That Your Lordship have quoted that order.
Headed by the District Collector.
Collector Kandhamal.
To assess the compensation amount and pay it to the petitioner, complainant, within an outer limit of
3 months.
3 months, without contending that the concerned authorities were not parties to these proceedings or to the writ petition.
Lordship may direct the registry to communicate an order.
I will do that. First, registry shall communicate this order to the what is that chairman of the committee?
That Collector Kandhamal.
The district collector, chairman of
Advisory Committee.
By speed post immediately for doing the needful action and thereby avoiding the possible contempt proceedings. Proceed. First. Hon'Ble.
My lord, item number 21, sub-item WPC number 23693 of 2025. There is an interim order, my lord.
We have adjourned that matter. Give back in that interim. Yes, sir.
Item 23.
May I
WPC 2026.
In this matter, petitioner is challenging annexure 6, page 26. The order passed by the.
My lord, before my learned senior begins, I seek further time to file counter affidavit. If the lordship granted time, we have failed in filing counter affidavit.
Proper judgment by this honorable court, and I have annexed
We have
that.
to receive instruction and file counter affidavit because we are opposite but not one, my lord.
You do it week after next.
2 weeks time, maybe.
That's what. So give some date.
Kete? 13th.
That is all right.
Yes, my lord. 13th. By 13th July, we'll file counter affidavit.
That's the request now. For filing the counter
Because this is a very peculiar case, my lord. The government is trying to recover the amount, the bank is trying to recover the amount. Who will recover? That is the question.
That will settle. I have annexed the judgment of this honorable.
After filing counter, because government is also OPDR case has been initiated. Now they are proceeding for recovery of their loan. We have to file counter affidavit, making this our stand clearly.
Latest judgment of the apex court has
Charge of the bank's
bank.
It is also, I am also annexed.
Even taxes and other thing.
Judgment also, it is a decreed by the DRT also.
That way.
That way. And it is 2015, 1 crore 87 lakhs. It became a threefold now in between.
Four, 2021-6176 of 2006.
The matter, my lords, where just to refresh your lordships, page 17, the sale notice, sale certificate.
The permission millers, really millers, they have challenged millers that the essay is not millers disposed of till date millers, though there is a direction of this on court millers. And our millers knowledge that millers, it has been disposed of 22nd millers.
Judgment already passed on 22nd.
Certain.
Yes.
It's really something very strange happening there. Something very, very strange happening there. Anyway, your worship, I call this matter day after tomorrow. I'll verify from the what has happened. And accordingly, I will take the steps in this matter. Yep.
Holiday.
Monday. Monday, your worship.
Judgment also downloaded matters.
Uploaded also.
Downloaded.
But please provide us copy.
Yes, should you not tell them?
Provide me a copy.
You are sitting here. You should
Provide me a copy.
I would a copy. I'm with that. I'm with a
You want copy.
22 means Monday last.
Monday. Therefore, perhaps your client has not received information.
No, in fact, my office is appearing there. My associates are appearing. So it's a special knowledge of people who had delayed the process so much. And once your lordship took cognizance of the matter, immediately the judgment has come. Let us see what, let me know what they will do.
Yeah.
Something very, very strange is that.
45.
Yes.
2872 of 2006.
Definitely, your lordship's pardon. The lordship's order dated 7 for 2026 has been violated. The lordship can come to page 11. My lord, one para from the bottom, two para, my lord. Second para.
My lord,
11.
I have received instruction that the order has been, we have complied with the order and we need to file compliance affidavit.
They have not reached.
That is the instruction, my lord. That is the instruction. We have to file a formal compliance affidavit only.
You file it next week.
Next week.
Panda appealing for the contempt of the subject that the order in question has been already complied with and formal compliance report should be filed. If reasonable time is granted.
My
Call this.
contention to be noted, my lord. My contention be noted that the order has not been completed.
We'll serve a copy, my lord. After service of a copy, my learning senior will say. ଆପଣ ଦେଖୁନାହାନ୍ତି
ଏଇଟା 14 all right? Mr. Khanda, 14?
14 July.
14 July.
Your Lord,
14 July, yes.
also directed if Shokad
Yes.
has not been issued within 4 weeks, my lord, then I have to be reinstated in service. They have not
Let us-
reinstated me in service. On 9/6, they have issued the Shokad. So they is saying that it has been complied with without reinstating me in service.
Let us. 9/6 was time part it was. Within what period they should have done that?
4 weeks.
4 weeks ended on?
7/4/2007 net 7/5. Maximum 7/5.
5/5. 4/5.
Now they issued so-called notice on 9/6 without reinstating me in service. So lordship specifically directed. If it had
Date is given.
Yes.
Then the order has to be complied.
100%.
Yes. Let's.
26, he has given 7 for 2004.
In fact, my lord, when I draft a complaint affidavit, I read it 5 times because it is coming before a lordship. The language, the tenor, everything I got. Because it has to be scrupulously complied with.
Given.
And if it is not compliance, I will not advise that for compliance.
That's. Yeah.
Well, I am now praying for a re-engagement in the post of driver as per order of this Hon'Ble Court in 2009. So the Hon'Ble Court by that time directed if a vacancy arises in post of driver, then petitioner's case shall be considered. So through RTI, I came to know that 23 vacancies are available in which I could have been adjusted. But when the impugned order, it is not impugned. So it is to some extent helpful to me. In the observing part, the corporation commissioner, page 16, last para, has observed that in view of the above mentioned facts and circumstances, it is stated that the post of driver or mechanic comes under the NFL, non-LFS cadre. Prior to appointment in a vacancy post coming under the non-LFS cadre, prior approval of the government in Housing and Urban Development Department is required. So they are saying that it will, if it is approved by the government, then your case shall be considered. But this order is passed on, my lord, to the present order in the year 2015, 28/5/2015. So by that date, my case was, prayer was governed under the Odisha Municipal Corporation Act 2003, whereunder the post Group C and Group D, Section 117(6), appointment to all post Group C, except the post of establishment officer, shall be made by the corporation, and in Group D shall be made by the commissioner. So in view of the Section 117(6), without sending the file to the government for approval, the commissioner has the power, commissioner of the corporation has the power under Sections 176 to take the final decision. So I pray my case be reconsidered in view of Section 117(6).
No, what is that you are challenging now?
No, my challenging page 16. But I was reading the repetition because the writ appeal. My case was having the prayer for re-engagement, but the Honorable Single Judge dismissed by considering it a case of regularization. So at the time of admission of my appeal, it was taken care of. It is not a case of regularization, it is a case of re-engagement. So my lord, the page 16, I was reading the order of the commissioner. In view of the above mentioned facts and circumstances, it is stated that the post of driver or mechanic comes under the non-LFS cadre. Prior to appointment in any vacancy post coming under non-LFS cadre, prior approval of the government in Housing and Urban Development Department is required as per provisions of law. At present, there is no such proposal for appointment on vacant post due to austerity measure. However, as and when steps will be taken, the petitioner is at liberty to take part, participate.
The selection process.
Yes, ma'am. So by that date, this order was passed in 2015. So they are saying that posts are not vacant. So RTI page, my lord, 31,
page 31, at the time of admission, your lordship was appraising this fact. Once the posts are lying vacant, sanction strength of the mechanic post 3, light motor vehicle is 23. So my post can be considered in the light motor vehicle 23. So this is the vacancy position as on 29/11/2013. 13, my lord. But earlier order was there 2010. When as per order of the Hon'Ble Court in 2010, I approached the commissioner. So commissioner in
your appointment itself is temporal. It is in a project.
I said that point I am not disputing. So it was already taken care of in the earlier writ petition. I confessed all the things. The Hon'Ble Court directed when the vacancy will arise in the drivers, the section of driver automobile section, your case shall be considered. So I am not exercising the 100% right because for my livelihood, because I was serving under the municipality as a driver. So being conscious of the fact that some post may remain vacant in future, the petitioner's case will be considered. So in the Annexure 1, page 16, they are admitting that it may be done, but subject to approval of the government. So it is the decision taken by the commission in 2015. But
what is wrong with the impugned order?
Well, I say because the read petition was dismissed as a case of regularization. I'm not playing for regularization. My case is for a re-engagement in the writ appeal.
No, even when they do not want to, can you force them to re-engage?
No, I am not enforcing any right for because my service is not existing under the corporation management. So there is no question of regularization. I was praying for a re-engagement.
Why they should re-engage?
No, my lord. The earlier order in 2010, my lord. This is the order. In the additional affidavit, I have the order. It is stated in which case that no supervisor post is available in automobile section of Kotak Municipal Corporation. And as such, Lord and Counsel for the petitioners praise that if any vacancy arises in future, the case of the petitioner shall be considered in the post of mechanic or driver. Accordingly, the order dated 17/10/2008 is modified to the extent that the case of the petitioner shall be considered for appointment as and when there is a vacancy in the post of mechanic driver in automobile section of the corporation. So as per this order dated,
which page you are reading, sir?
My lord, the additional affidavit, Annexure 10. Annexure 10 series. The order passed in OJC 4051. 4051/2000. The order, modified order on 17/3/2009. In 2009, as per this order, modified order, I approached the commissioner. So commissioner passed the order in Annexure 1 saying that prior approval of the order of the government is required. So I say, my lord, I submit because driver belongs to the post of Group C. So in respect of Group C and Group D post, the commissioner has the power.
What do you say?
A simple prayer because reconsider.
Regulation part, Manoj, admittedly has no case, and that is the order of that has gone against him.
The order dated 17/10/2008.
9.
No, 17/10/2008.
But one thing, Manoj, if you may kindly see the impugned order, Manoj, page 17 and 18. Well, he was engaged for a brief period of 44 days only.
But that's not the but where the learned single judge has considered this aspect of the matter. Can one learned single judge ignore the order of another single judge?
No, Manoj. Only thing, Manoj,
you come to page number. What do you know?
Affidavit, well, additional affidavit.
Seal of the page number. OJC number 4
OJC
of 20. How the seals are put? We cannot read it all. They tell your archie that seal to be put somewhere, not on the printed material.
Restricted seals will take care of.
But 4051 of 2000. I'll come to that order.
17/3/2009.
17/10/2008.
17/3/2009.
The order I have annexed by Annexed 10 series of the OJC.
Yeah, we are seeing the order only. Order number 8.
My lord.
Heard. It is like that. Different. This is order number 9.
Order number.
This is order number 8. Go to order number 9. Order number 8 was another writ petition.
No, my same writ petition. From this case, it was modified. The earlier order was modified.
Earlier order was
modified 2009. Original order 2008. So modified order 2009.
You are right. It's here. Mysterious case number 804. It's here. It's an application for modification of order dated. Post of mechanic for driver. According to the order date 17 modified to the extent that the dates of the petition shall be considered for appointment or absorption as and when there is any vacancy in the post of mechanic or driver in automobile section of the Cuttack Municipal Corporation. Where is the reference to this order by the learned single judge?
My lords, page 13 of the writ appeal.
1313.
My lords.
What he says?
Aggrieved by the inaction of the Cuttack Municipal Corporation and having no other recourse, the petitioner filed a writ petition being OGC number so and so of 2000 before this court, seeking a direction to the opposite parties to re-induct and regularize his service in the post of supervisor or any other suitable post commensurate with his qualifications. This court, by its order dated 17/10/2008, disposed of the writ petition, directing the opposite parties to consider the petitioner's case for appointment when a vacancy arises in the post of supervisor in the automobile section of the Cuttack Municipal Corporation.
That is order number 8. Where is the reference to order number 9? Order number 9 is dated 7/2009.
My lords, page 15.
15.
My lords,
that also is considered.
13, my lords, Roman 13. The modified order of this, my lord, it has been discussed in the order. 17/3/2009, my lords.
17/3/2009.
Order number 9, my lords. In this case, so and so, in OJC, so and so was cogent and forceful. My lord, this is the submission of the petitioner has been discussed, my lords.
Where is the requirement of prior approval? Come to para 9, 14.
It is pertinent to mention here that while disposing of the representation, the OP4 indicated that the post of driver or mechanic comes under a non-LFS cadre. Prior approval of the government in housing is required as per the provision of the law. At present, there is no.
Commissioner. Commissioner is the appointing authority, which your friend has now pointed out. If it is some other position, maybe approval of the government may be required. But for commissioner, who is the appointing authority? That section.
Section 117 clause 6.
Yes, friend, look into
Municipal Corporation. Appointments to all posts in Group C except the post of establishment officer shall be made by the corporation, and in Group D shall be made by the commissioner, subject to the provisions of bylaws, if any, made by the corporation.
The driver is what? Group C or Group C?
Group C.
Group C. Then corporation has to make the appointment.
Yes, my lord.
When is prior approval is required?
No, nothing. No prior approval. Commissioner is competent.
Brother, what do you say about that?
Well, that earlier he was, my lord, posted as ward supervisor, my lord.
Now there are two orders. One is in 2008 April. Another is in March 2009. April order is order number 8. March order is order number 9. They have said whenever vacancy arises, he will be considered for, of course, they use the word absorption. No issue. My friend is saying not even absorption. Let them re-engage.
He is not applying on regulation, he is praying for re-engagement.
Re-engagement.
Because he is
supported by two orders.
Because he was disengaged in 2000, my lord. Thereafter, after lapse of so many years, my lord,
you just consider it very consideration.
If a lordship may grant some time, keep it to next week, my lord, I will obtain instructions specifically regarding this, whether any consideration was done pursuant to this order or not.
Learned counsel for the petitioner drew our attention to two orders made earlier. One in April 2000. 17.
1710 2008
1710 2008
and 17-3 2009
and the
17
other order
17-3 2009
2009 on made on miscellaneous case number 804 of 2008. First, apparently in OJC number 4051 of 2000. Thereof, first, he also draws our attention to the provisions of section
117.6 of Odisha Municipal Corporation Act.
Odisha Municipal Corporation Act
2003
to the effect that it is the corporation which makes appointment to Group C boards, and that there is no need for approval of the government at all. And therefore, in terms of the said order, the candidature of the appellant should be considered for engagement as driver in the vacancies that have already accrued. First, he tells that this aspect of the matter has not been properly dealt with by the learned single judge. First, at this stage, learned panel considers appearing for the
CMC members, Conduct Municipal Corporation,
local body
OP3.
Submits that he would confer with his client and come back with some solution positively. Hopefully. First, to facilitate the same, call this matter on 21st. 24. You have to come with positive this one. See, there are two orders now. Therefore, you have to do something in the light of those orders.
My lord, specific to that re-engagement, I will.
Yes. First. Yes.
Item 27, with appeal 5183 of 2024.
Color. Or maybe